Yeah, well, good morning, everybody. It's really great to see you here, and as Chairman of SULI, can I extend a very warm welcome, not only just to those who've braved the virus to come here, but also to those who are watching on the live stream. It's unfortunate live streams are a one-way device, but I can assure those that if you're not, who are watching by live stream, that will keep you in mind even if you're not in view. I think there is an ability for you to be able to submit questions or comments, but I think, and Barry will explain the mechanism for that in a few minutes when I hand over to him. I have to confess that it's really a very strange but very welcome experience, again, to be seeing people after all these years of lockdown and isolation. And it really is very wonderful. And I hope that we're all going to enjoy this, which I think is for many is probably the first real face-to-face get-together we've had for months. Today's event is the second conference, of course, which SULI has organised. And I think many of you would have been at the first and very successful event in Dundee. I think we really want to follow the same broad purpose of showcasing the works which are in pipeline due to publication, but we're very indebted to having a lot of distinguished speakers to come with their reflections on topics current to their work and to Scots law. We also see it perhaps as an opportunity for those who are preparing works for publication to interact with the readers and for the readers to interact. But above all, I think we aim to provide a long-awaited opportunity for a real live debate and discussion about matters that are relevant to us. Now, it's all part of, I think, the SULI's wider aim, wider charitable purpose of fostering Scots law, the study of Scots law and its literature. And perhaps I could just put in a plug for our scholarship and fellowship schemes. We set them up. This is now just completed the second round, and this is, I think, going to be an enduring feature. So I just put in a kind of a trailer or a plug that you might like to publicise the existence of this research facility, among others. Well, I know that time's very short, so I think perhaps with those few words of welcome, I'm sure we're going to have a very interesting day. And Barry, the director, who's, along with his team of organisers, have done a lot of work in preparing this conference. I'll hand over to him to tell us, among other things, about how you submit comments if you're watching on live stream.
Thanks, Ronald. Thank you very much for that introduction to today's event, to our conference, showcasing some of the forthcoming SULI publications, and many of our authors are here today, so thanks for taking the time to prepare your presentations and do the work for this. Many thanks also, as Ronald alluded to there, to Michelle Weldons-Johns and Pamela Ferguson, who have helped me to organise today's event. So a welcome to everyone that's here and to all of you who are live streaming. I'll be chairing this first session, which is on Scots private and commercial law, and we will have a mix of live presentations and a pre-recorded video. You can submit questions at any stage using the chat function. I think it's similar to the chat function on Zoom, and that will allow me to make questions to the presenters. We are going to have the presentations followed immediately by questions on those presentations and then move on to the next presentation. So try and get in any questions as quickly as you can. Okay, so without any further ado, I'll move to the first set of presenters on the structure of the modern law of Delict. And we have two speakers here who are working on the final chapter of the Delict book started by Joe Thompson. Jonathan Brown's a lecturer in Scots private law, a colleague of mine at the University of Strathclyde, and he teaches commercial law, obligations. He started a Roman law class, and he's got a number of recent excellent publications, including such matters as medical jurisprudence, legal personhood, and the utility of the actio injuriarum in contemporary Scots law. And he's joined by a former colleague of mine who really needs no introduction whatsoever, Professor John Blackie. So, John and Jonathan, I'll pass the floor to you. Thank you.
Well, thank you very much, Barry.
Thank you, yes. We are doing the chapter in the Lucy volume of Delict, SULI, and it's the first chapter. I think there's one other still to come, but it's to provide a structure for the whole thing. So, Delict is not like some bits of law. Really, contract, for example, you've got your structure, pretty much, and then you work within it. So there are various competing possible structures, and this is true of many other legal systems as well. So I think that it's first of all worth looking at some criteria that we would be having to weigh this against. Now, I have lots of criteria there. I think that the most important ones are consistency, you see, amentices, consistency with the whole corpus of sources. And there are other desirable things, but a very important thing is okay in its legal logic, and ultimately, I use the word convenient, but really useful would have been good, so down here, convenient for the whole legal community. It's got to be usable. It has to be usable because it has to deliver. And so that is the criteria which we have applied. Just in passing, I would say, too, that in the nature of this, there's no point in writing a history bit and then a today bit. It all is melded together. It's not the case that no judge has ever tried to produce of Delict. And quite famously, in relatively recent years, Lord Hope did in Kennedy against Glenn Bell. An important thing in this rather long quotation is the first line, that the essential requirement is that there be fault or culpa must be established. However, the fact that the thing goes on then for line after line after line, this was in the context of support being removed in a building, it's actually in Exchange Square here, it suggests that he then is having some difficulty in working with that concept, and he talks about implied culpa. We are going to suggest shortly that the model that works is actually not this one. So we then move on from that, and here you come in.
Yes. So, of course, as John says, we are going to move to discuss the fact that this model proposed by Lord Hope there, the idea of an overarching unitary notion of culpa, is not, in fact, sufficient to satisfy the criteria that we laid out in slide 2. But we have to note, of course, that on the face of it, the suggestion by Lord Hope was, of course, informed by academic scholarship, particularly across the 19th and 20th century, and it's consistent with a great deal of that scholarship as well, to the point that the dominant model, again, for most of the 20th century certainly, has been placing the notion of fault or culpa almost at the top of the tree as being synonymous with the whole of the law of delict. You can't have the commission of a delict if you cannot establish that the defender was at fault for the incident that occurred. And within the taxonomy of that model, it's been said, of course, that although strict liability is well recognised and exists, it's a bit of an outlier which exists separate to the regime of culpa, but culpa being the governing criteria essentially splits the law of delict into two, with there being intentionally committed delicts and unintentional delicts, with the overwhelming majority of scholarship and overwhelming majority of cases calling before the courts concerned with delicts which have occurred unintentionally. That is where there has been some negligence on the part of the defender, and quite famously following the case of Donoghue against Stevenson, which everyone is, I imagine, familiar with. The notion of the duty of care comes to the fore, with the notion being that one can be at fault for an unintentional wrong if and only if a duty of care has been breached. Now, of course, the focus being placed on this idea of negligence means that although it's recognised that delicts may be committed intentionally, there have been at times cases which have considered the notion of the duty of care within the context of intentional delicts as well, which authors such as Professor Thompson have, of course, criticised in works such as the Scots Law Times and articles for the Scots Law Times. But many points in respect of the law of intentional wrongs become quite difficult to fit within the culpa model, as Professor Blackie will talk about momentarily.
Yes, and one of the, this side of it is becoming increasingly important if you look at the case law. So we really need to see that what I call delicticals, and what we're using the word delicticals, derived in fact from torticles in England, that in fact the courts have to work with specific delicts with names, if you like. And so introducing you to delicticals, if you know what that symbol means, if you did any mathematics, there is no definite closed list of the delicticals. Some are created by statute. Anybody who does industrial safety cases, accidents of work, will know that. And strict liability lies in here, but it's not unimportant. If you think of products liability, it really matters on the ground in today's society. So I think we can now move on to the next one, and back to you, Johnny.
Yes, because essentially that is the core idea here, that for the longest time throughout the 20th century, fitting the model of strict liability into any kind of theory of delict has proven to be quite problematic, even, of course, within the Roman corpus of sources itself. What we would call today matters of strict liability were not really regarded as delictual per se, but rather quasi-delictual. But certainly in the 21st century, we're of the view that any satisfactory theory of delict has to take into account the possibility of strict liability, and also has to be able to explain or justify the occurrance of intentional wrongs out with the context of what we have termed here delicticals. Now, of course, the idea of culpa has, as we've said, it's become one of the central theories and ways of explaining the operation of the law of delict. But the previous SULI volume on delict by Professor Walker in 1981, there's a quotation from him there, which notes, of course, that although he begins by saying that the fundamental concept is that of a breach of legal duty, that matters such as infringement of personality can be referred to injuria alone. That is the Roman notion of the actio injuriarum as received into Scots law, with damage to property being rationalised under principles of culpa. So in Walker's earlier text, there is actually an indication of a bifurcation of liability and delict, general principles of liability and delict as arising under both what would be termed Aquilian liability and liability under injuria. Yes. And that is consistent with what Professor Thompson agreed with Lord Rodger of Earlsbury in the preface to the volume which we are contributing to. Professor Thompson noted that it was the fact that they formed the view that the law of delict could no longer be explained under one principle, such as culpa, that ultimately led to the collaborative and multi-author approach taken to the loose leaf volume itself. That, of course, also led to the necessary conclusion that in Scots law today, different interests are protected in different ways, which are often, very often, in fact, quite far removed from the personal injury cases, which would have been regarded as paradigmatic throughout the 20th century. So the question then is, does this take us to what John and I have termed a full delictical model, essentially a quintessentially English view of delict?
Essentially, the full delictical is that you have delicts with names. And this you can find some support for. In fact, in early Scots law, well, at least by the 18th century, and here is a Bankton list of delicticals. The important thing about that is to see that it is a list, but that some of them we wouldn't possibly think today is that, for example, escape of a prisoner. That was a liability of the prison jailer for the escape of a prisoner. One is gone, battery pendente lite was abolished in the 19th century. But it does show that the idea of working with delicticals was already there in Scots law right the way at the back. And then, though Stair here says that there are some with names, and he emphasizes damage and interest, and but some are general, and Bankton refers in his list to injury, and that's injuria in the sense that Jonathan has just described it. So then we move on.
Yes, so the reason then that the idea of the full delictical model is not, although it isn't without historical precedent in Scots law, it does not necessarily fit with the actual operation of the Scots law of delict as a unified field rather than a fragmented body of separate delicticals, because it has long been stressed in Stair's work itself and in others that delict is open-ended, as Lord Hope recently recollected at the Bill Wilson Memorial Lecture in 2007 with a contribution printed in the Stair Society Miscellany of 2009. There is no such thing as an exhaustive list of named delicts in the law of Scotland. If the conduct appears to be wrongful, the law of Scotland will afford remedy, even if there has not been any previous instance of liability. Likewise, in Professor T.B. Smith's short commentary on the law of Scotland, it's recognised and described that the categories of liability under the principle of culpa are never closed and are of great variety according to the perverse ingenuity of the human mind. So in effect, the categories of culpa are not closed, and the potential for liability under injuria cannot be circumscribed either, which of course echoes Stair as well. So to explain the law of delict satisfactorily, We can't simply say, oh, well, we'll have a list of named delicticals. We need a more general model taking into account some degree of principle rather than a simple list of actions.
So we move to another model now, and but very quickly I'm passing over some little bit of history. This dates from my own work some years ago, and I want just to point out here, I was in fact writing about the protection of personality rights, and that introduces us to various forms of protected interest, which I have along the bottom there. And up here is inuria, injury, but over here is what's called Aquilian liability, liability for damage to interests that are not of just this sort. The next one we can pass over relatively quickly, but it's here. Sorry, it got simpler in time.
So that was the first complicated one.
And then it gets simpler, but it's still complicated.
Yes.
And then we get then to a completely different model. Now, this is a good-ish candidate for Scots law, but we think not good enough. This is very much like German law, in fact, if anybody is familiar with German law. You start at the top with a category wrong, which means source of appropriate civil liability. Underneath, you have damage to the interest, so that's damnomina language often. And then you have a list of protected interests and rights. Now, it's not possible, I don't want to have a huge, great list of them, but I think it's quite telling that I've put up economic interests there, property separately from that, personality, and I've got human rights here. And reputation separately. Now, the lines, what then becomes very difficult is you land up with all these different forms of conduct or absence of conduct, or strict liabilities, and we did something. Now in human rights claims against the state, it's rather very recent, UK Supreme Court authority, we actually have acting affirmatively, rescuing people, is really confined to human rights law, and really those claims, it's a question as to whether within Delict, I personally think they are, but they're a different kind of claim, and it's on a different basis. We've used the word malice here in inverted commas just as a placeholder to deal with various types of intentional conduct. But fundamentally, although this reminds us of the fact that there is no definitely closed list of protected interests, which is a major problem for German law because they did have a closed interest and they had to invent some. And that's why I put political. Say somebody stops you on the way to voting on the other side. And the other thing is novel interests. We can never think today we have recognized all of them, and there might be ones come long after even Johnny is dead.
Oh, yes.
So then we move to our choice model.
Because, of course, the previous model there, just to look at that again, is very complicated. That's not a reason for rejecting it in and of itself, but the fact of the complexity makes it more difficult to work with and then prospectively less useful as a model as well. And likewise, trying to think of new interests and predict that, as John has said, is a fool's errand quite often. So our model instead, or our proposed model, is one which we hope is more consistent with the sources and fits the desiderata that John identified in slide 2. And that is essentially recognizing at the top level that there is no one governing principle such as fault, but that fundamentally the law of delict is the law of wrongs. and there are different ways in which these wrongs can be committed. There are two general principles under which liability can develop flexibly. Those are the principles of culpa and that of injuria. In effect, injuria dealing with any what would be termed contumelious conduct, that is, any time in which the wrongdoer has behaved with a hubristic disregard of the rights and interests of the pursuer. The notion of culpa, of course, can evolve, as we've seen in the context of the law of personal injury and economic loss, and so on and so forth. Culpa essentially is concerned with loss primarily. So those two general categories can evolve and develop within the common law. Likewise, interference to property, although it's quite easy to categorise wrongs, nominate wrongs such as SULI, as matters purely concerned with property law, we think that there is a place for these within the law of Delict, and that they should be described in part. I've been told to be quiet by this, but I'll have to sum up quickly.
Maximum 5 minutes left.
Right. Yes.
Sorry, how do I step this up?
Yes. So interference with property has to be explained on this model as well. And likewise, of course, it's recognised that statutes can create entirely novel forms of liability in a kind of delictical type model, but likewise that the common law itself can develop new named delicts which have their own requirements for liability, which may or may not be strict, in fact, but which have really left behind the general principles of culpa and injuria, which we are discussing presently. So where this model is concerned, we explain the notion of strict liability simply within reference to interference with property. Interference with property unquestionably results in what can be termed strict liability. There is no need to consider matters of fault in connection with this, unless there is additionally an element of loss being complained of as well, as in the Kennedy against Glenbell type situation. So to illustrate this principle, one can petition for an interdict if someone is a nuisance. It doesn't matter if the person is culpable in being that nuisance. The fact that they are a nuisance is, or can be, sufficient to obtain an interdict within that context. If, however, the nuisance has caused a loss as well, as in Kennedy against Glenbell, there is a requirement to demonstrate fault, and that's because the matter of culpa is relevant where what is being alleged is loss caused by wrongful conduct, the damnum injuria datum of the lex aquilia. Now, injuria is separate from culpa, notwithstanding the fact that the term injuria, of course, appears in the appellation of damnum injuria datum. That is because injuria as a separate governing category is not at all concerned with loss. One does not need to prove that one has suffered any kind of loss if one is alleging that a wrong such as assault, rape, deprivation of liberty is concerned. One only has to show that the wrong occurred and that it occurred with the defender demonstrating a contumelious mindset vis-a-vis the pursuer.
That doesn't mean to say, of course, that if there is loss, which there normally is,
yes,
that you can't recover for that.
Yes.
But it is that you can recover something. It's quite a complex problem as to how you assess that something, but it is in essence for the fact of the delict having occurred.
Yes, because that's a core point here, is that especially where culpa, injuria and interference with property are concerned, all three of these can overlap within the course of a single action. They are appearing here as exclusive categories, but that is simply because there is no necessary link between them. It is possible for one to have liability arising out of loss caused by wrongful conduct with no interference to property or no injuria having occurred. But likewise, as John has said, possible for all of these to coalesce
Now, could
together.
I just briefly put in my oar here at the end? You'll notice vicarious liability. We have treated as applicable right across the board. We can't, we think, fit it into one box or another box, and it's better seen as something potentially covering the whole law of delict. Of course, we know it's restricted in our law to, well, largely to employer-employee, but has been somewhat extended over recent stuff. And of course, it does apply to all sorts of things. Finally, to say I put in statutory delicticals. The statute law is increasingly important. A lot of our strict liability comes from that. But there are some common law delicticals that absolutely, definitely have to exist. And a very obvious one, we think, is breach of confidence. Breach of confidence has its own rules. We know what they are relatively well. And I'm thinking particularly, for example, say, of commercial breach of confidence, trade secrets, that sort of thing. So you can't bring that just within privacy. It's something different in Scots law today. So there we have it. Thank you very much.
Thank you, John and Jonathan. That was absolutely fascinating. And it is built on earlier work that I've heard from yourself, John. I think sort of your work and your viewpoints sort of inspired partly by the difficulties involved in strict liability and by the increasing range of different interests that have been protected by the law. At one stage, if I hadn't known both of you better, I thought you were going to just throw your arms up in the air and say, well, there's nothing we can do. This whole area should now be called the law of delicticals, with no overarching theory or model whatsoever. So I think it's really interesting that you've developed this slightly more simplistic model at the end. There's still an issue, it's a linguistic issue about the use of the word wrong. Now, I know about the use of the word wrongs from German law, and I've heard you talking about that before, John. It's just that sometimes in Scots law, wrong becomes used perhaps erroneously, as you're suggesting, synonymously with culpa, and I think that's maybe something, but really, really fascinating.
Just, can I respond to that?
Yeah, absolutely.
Duty of care, it works, of course, fine for negligence. Mm-hmm. It becomes a control device, and we're all very, very familiar with that. In other legal systems, the control devices are at a higher level, so they apply right across the board, if you like. And it is very, very difficult to find a word, because it's inevitably going to be used in a technical sense. Just to give you an example from the draft common frame of reference, European Union, in which I was involved in the non-contractual liability for damage delict victims essence. Now, that has a very complicated thing in it, which is not a general clause like French law has a general clause. You know, if you have anyone who's committed fault, they are liable. Well, summarizing, of course, but it's this thing. But it says that it has to be legally relevant damage. Now, damage in that particular context does include what we would call the injuria type damage. But then it has to go on to create criteria, and these criteria have to work across the board. It also works with delicticals, by the way, as well, which some of the continentals hate, but there we are. So we appreciate the difficulty about the word wrong.
Yeah.
And if anybody can come up with a good one for us, we will love you.
Are there any questions from the floor? David Cabrelli. David, do you want to tell me, and I will repeat it for...
How do we do this?
You say stuff and I will repeat it.
So thank you very much for your presentation.
Thanks for your presentation from David Cabrelli. Yeah.
How do you want to do this? Well, I do.
Just say make it a brief question.
Yeah. So essentially, what you seem to be doing is searching for a unifying single justification or principle, if you can, for the entire area of Delict. Is that correct?
So essentially, the question is, are you looking for a unifying single principle or justification for the Scots law of Delict?
And what you found is that there isn't one. There are a number of principles.
And is it that in fact, there are simply a number of principles rather than one overarching idea?
And if that is the case, and as you presented, you're proposing that it's damage to property, culpa, injuria, and then statutory delicticals,
And common law delict.
and common law delicticals, then can you explain how would you weigh these principles in deciding in a particular case? Are they yeah, the issue, I suppose, is how do you set them off against each other?
Mhm.
Because if you're saying that these all explain Delict,
Mhm.
then how, as an uneducated observer, would I know which one applies in a particular case?
Okay, so I think the question is essentially about your model form. How do these different interests weigh against each other, or how do they balance, or how do you use them in a particular case? And I think that's
Take that one just now,
Respond
yeah. So essentially, it's not about, again, balancing, and again, it's about recognising that although they look very separate, because I'm not a graphic designer, I'm not very good at that at all.
I did that.
Yeah, but they're not completely separate. This is merely there to show that these can be separate from one another, that any one of these 4 or 5 things can result in intellectual liability, but the question is one of circumstance. So we're not separating out damage to property, merely separating simple interference with property away from matters of culpa and injuria, and saying there's no point in saying that these are a list of nominate delicticals concerned with interference with property. We're saying that, in general, the law of delict, that is the law of wrongdoing, will regard it as wrongful if you interfere with property. And you don't need to demonstrate anything more than that baseline level of wrongfulness. It is wrong to interfere with someone else's property, therefore you have a delictual action against anyone who interferes with your property. So that is where that box comes from. The box in connection with culpa is, as it says in the slide there, the one with which we most often and most basically associate with delict. If a loss that can be what we term in modern language personal injury, or it can be damage to property, or it can be a pure economic loss. But if a loss has been suffered by the pursuer, and that loss was caused by the wrongful conduct, that is the fault of the defender, then that is delictual, and that justifies an action. And separately from that, if there has been injuria, for example, if the defender has assaulted, has beaten, intentionally attacked the pursuer, then that will result in liability, notwithstanding, and there is a complication because, of course, we think of an assault as generating both physical injury in the sense that links it to culpa, but also it is an example of injury in this more technical sense. So a beating assault is not any longer a good example of the type of injuria that we're talking about. But what would be, perhaps, would be if one is on the subway and a pervert grabs your arse. Then that is an assault because it is hubristically disregarding your bodily integrity. Now, you might not necessarily have lost anything. There might not be any enduring physical injury there, in that sense, justifying a culpable action. But there certainly should be an action there. And just because there haven't been cases in which people who have been sexually abused on the subway have taken their assailant to court doesn't mean that there can't be. This sort of thing can, of course, occur. And we see with, for instance, the civil rape cases that have occurred lately. Rape described in the current Delict volume as a pure actio injuriarum as well fits within that model. So I hope that answers your question, David.
I mean,
Okay,
a good example
thanks,
of
yeah.
that, I think a better example is actually somebody spits at you, but it doesn't land on you.
Yeah.
There is, we say, a delict
Yes.
in that. I mean, criminal law has, of course, has its own rules, and there is an interesting question about the boundary line.
Well, that's not going to happen today because we're all socially
Yeah.
distanced, so we're fine. I'd like to just draw this this presentation to a conclusion, thanking both of you, and I think we're all really looking forward to the chapter that will bring the Delict volume to a conclusion. And just on that note, that there will be a celebratory event at some stage within the next year or so to celebrate the law of Delict being concluded and to basically thank posthumously Joe Thompson for all his work in relation to that. So there'll be further details of that. If you have any further questions or comments about John and Jonathan's paper, please use the comment section. We can gather those comments. And the same, I would say the same for the next session, the next presentation. The next presentation is a pre-recorded video on spouses and partners, cross-border issues, by Kirsty Hood. Kirsty Hood's unable to join us today, unfortunately, and so has delivered this pre-recorded video. Again, so you won't be able to ask any live questions of Kirsty, but if you have any comments or questions or points to make, again, please put them on the chat and we will pass them to Kirsty. So Kirsty will be known to most of you. She's an advocate at the bar. She has particular expertise in private international law. She's the author of Conflict of Laws within the UK. She's a contributor to the third edition of Wilkinson and Norrie, the law of parent and child in Scotland, and is a contributor of the cross-border jurisdiction section of the Scottish Family Service Loose Leaf. So we are now going to watch Kirsty's pre-recorded presentation.
Thank you very much for giving me the opportunity to speak today. I'm one of a team of 3 authors, together with Lady Wise and Ruth Innes QC, who are working on the SULI text, The Law of Spouses and Partners in Scotland. The starting point for this will be the 4th edition of Eric Clive's work, The Law of Husband and Wife in Scotland. And as you will immediately gather from that, the new text, both in its title and also in its structure, will reflect the major changes or reforms, both domestically and internationally, which have occurred over the intervening years since the last edition of Clive in 1997. And those reforms include, perhaps most obviously, the extension of marriage to encompass not only different sex, but also same-sex partners, the introduction of the civil partnership, and recently its extension so that it's available both to same-sex and to different sex couples, and also the greater protection of cohabiting partners. Now, obviously, the text will cover a wide variety of topics, and therefore there are many, many things that we could talk about today. But what I want to concentrate on in this short presentation is what is the main focus, not the sole focus, but the main focus of my own contribution to the text, which is the cross-border aspect of spouses and partners, how our legal system interacts effectively with the legal systems elsewhere. Now, that involves consideration of issues across the whole spectrum of the various aspects of the topic, but it involves issues arising across that spectrum of when Scottish courts will have jurisdiction to hear a particular action, when Scottish courts are hearing an action which has cross-border aspects, what law should they apply? And separately from that, in what circumstances ought Scottish courts, and ought therefore our system, to recognise and, where appropriate or necessary, enforce a decree or judgment from a system out with our own. Now, all of these issues could arise at different times within a relationship. They could arise when entering into the relationship or even during the relationship, and they could arise obviously when the relationship ends. It's often the case that these issues will crystallise when a relationship ends for one reason or another, whether that be because the relationship breaks down or whether because of the death of one of the partners. As we consider cross-border aspects of the topic, it is, I think, necessary to talk about, to acknowledge the UK's withdrawal from the EU. Now, I realise if I were in the room just now, I might hear a bit of a stifled groan, as some people would think, goodness, I think I have heartily heard enough, both in general political discourse and at various legal conferences and seminars over recent years, of UK's withdrawal from the EU. But it is necessary that we touch upon it, because obviously it's part of the historical development over recent years. The EU has been active in this area because of the importance of family law in terms of supporting the freedom of movement of workers and their families. So as I say, it's part of the historical backdrop and explains where we are now. But it's also relevant because despite the UK's withdrawal from the EU and the end of the transition period, which ended at 11 o'clock at night on the 31st of December last year, 2020, despite that, a number of EU instruments do have a run-off application. And the instrument which is most relevant in terms of family law and specifically to adult relationships latterly was the Brussels 2 bis regulation that replaced an earlier predecessor, Brussels 2 regulation. And indeed the Brussels 2 bis regulation will in quite short order itself be recast or replaced by an updated regulation. However, the Brussels 2 bis regulation was a regulation which had the most impact in the particular area which the text is concerned with. And as I say, it does have a run-off application which will have to be flagged in the text. With respect to jurisdiction, the impact is realistically somewhat limited, because really it will only affect proceedings for divorce or nullity in different sex marriages which had been commenced before the transitional period ended at the end of last year, but where the issue of jurisdiction remained live as one which had been contested and yet had not been resolved. And as one would expect, quite logically, plainly the courts, in terms of deciding whether they had jurisdiction, have to measure that in terms of the jurisdiction rules which were in place at the time when the action was raised, and therefore the Brussels 2 bis regulation may be relevant to that extent. With regard to recognition, the impact may be more significant. Essentially, if divorce or nullity proceedings were raised at a time when the EU instruments applied, then the recognition rules of Brussels 2 bis will continue to apply to the judgments in those proceedings if Brussels 2 bis was relevant. So there we're talking about intra-EU recognition of judgments. But obviously the main focus of the text will be the current position in new cases. And with regard to jurisdiction, the position in Scotland will see us really return to what were our residual jurisdiction rules for actions of divorce or nullity. When I say residual there, I'm thinking about the rules that we had in place and which were then overlaid by the EU instrument, the Brussels 2 bis regulation. So that residual rule, which was giving the Scottish courts jurisdiction if one of the parties was domiciled here in Scotland, that will return to take primary importance again, but it will be supplemented now also by the possibility of the Scottish courts taking jurisdiction on the basis of the habitual residence of one of the spouses. Now, habitual residence is a connecting factor, which I think it's fair to say is now the preferred connecting factor in many more modern instruments, and the Brussels 2 bis regulation was no exception to that. Habitual residence was really the key to the various potential grounds on which courts could take jurisdiction in that regulation, with a more limited rule for domicile or with regard to other EU countries other than the UK and Ireland nationality. So say that's the position in Scotland, and that will be the position across the board, whether it's a different sex marriage or a same-sex marriage or a civil partnership that is being dissolved. And also remembering too that for civil partnerships and same-sex marriage, there is also a protective ground of jurisdiction, a ground of jurisdiction really aimed at the situation where a couple has entered into a same-sex marriage or a civil partnership in Scotland, and now find themselves in a position where the country which would most naturally have jurisdiction to dissolve that relationship is one which does not yet recognise a same-sex marriage or doesn't recognise a civil partnership, and therefore the Scottish courts can step in to take jurisdiction to dissolve that relationship and therefore unlock the problem which would otherwise present. Interestingly, in England and Wales, a slightly different approach has been taken in terms of the jurisdiction rules applying for divorce and nullity proceedings post the Brussels 2 bis regulation there. And they have chosen to really incorporate into their domestic law most of the grounds of jurisdiction which were contained in the Brussels 2 bis regulation, along with a slightly expanded role for domicile, slightly expanded upon the role that Brussels 2 bis would have allowed for domicile. That immediately raises the issue that we may have a situation where there will be different grounds of jurisdiction in Scotland and in England and Wales, and therefore raises a situation where it is possible that parties may be faced with a potential choice as to where they raise a divorce action. Now that brings us to the age-old question of what happens and how legal systems confront the situation where there could be multiple proceedings, or where there are multiple proceedings. So a situation where, for example, the husband raises an action for divorce in one jurisdiction at the same time as the wife is raising an action for divorce in another jurisdiction. And there are all kinds of arguments there as to whether that is something to be deplored or whether that is simply a function of party choice, and all sorts of issues about how we do actually deal with that to avoid unnecessary duplication, but also as to whether we ought to have something in place to recognise that perhaps it might be more appropriate for a variety of reasons connected to the particular marriage that one court rather than another should hear the action. Underlying that, of course, is the issue as to why that might occur. Why might it be that one party would seek to raise an action in one place and one party might seek to raise an action elsewhere? Well, of course, it may be partly convenience. It may be that after the spouses the relationship is broken down, that they have separated and now reside in different countries. And it may simply be the convenience and cost of raising in one place rather than another. But of course, there are other reasons why a canny and well-advised party may wish to raise proceedings in one court rather than another. And indeed, it is widely known that there are certain courts which may be seen as more attractive for a spouse to raise proceedings. And we might say, well, why would that be? But the answer lies in choice of law. because it is the position in Scotland, as in the rest of the UK, that in many aspects of family law, the position has always been that it is seen simply once the court has taken jurisdiction to hear a case, that that court will apply its own law. Therefore, to take, for example, a divorce action, if a Scottish court or a court in England and Wales has satisfied itself that it may take jurisdiction to hear the divorce and also to deal with the financial consequences of divorce, then that court will simply then proceed to apply its own rules in order to deal with the case before it. And as you can immediately appreciate from that, differences in the domestic rules of the various countries, differences in the approaches which are taken to principally how parties' finances and assets ought to be dealt with on a divorce, could well play out very differently for the different spouses. And therefore, that may mean that one spouse is particularly anxious to raise their action in one particular jurisdiction. So we see there that the importance in the real lives of people and in the real cases which come before us, the importance of jurisdiction and choice of law in terms of how a party's divorce is dealt with and how that affects their financial situation. Insofar as the Brussels 2 bis regulation was concerned, the issue of multiple proceedings was resolved as between the various EU member states by way of a lease pendens rule, and that is the normal approach of EU instruments, and that was the approach certainly for adult relationships within Brussels 2 bis. There were differences with regard to how proceedings for example, the residence and what we would have seen as custody and access cases for children were dealt with. But leaving that aside, as we're concentrating here on adult relationships, the lease pendens approach, the traditional EU instrument approach, was taken. We'll see that disappear from the landscape in that form, but then we will simply use the system of mandatory and discretionary cists, which was the position in Scots law previously, and which will again become our primary way of dealing with the issue of multiple proceedings or potentially multiple proceedings in this field. I think my time is running short here, and I just want to flag up too that it will be necessary, as I indicated at the beginning, to have some discussion too of recognition. The situation, for example, decrees of divorce or nullity that come from out with the Scottish system. What are the circumstances in which we would recognise those decrees or judgments here? But as you will see, even from that very brief discussion, even just taking that one aspect, which we will cover in the new text of looking at the up-to-date position on the cross-border aspect of spouses and partners, the international changes and the impact that has on us mean that it is very important that we understand the historical steps that have taken us to the position we're in, and most crucially, that we understand the detail of the current position. So as I say, given that even just to take that one aspect, that international change and in our domestic rules, the important and significant reforms which have occurred in our domestic rules over the past decades, you will see there that we have many, many interesting things to cover in what will be the new text of spouses and partners in Scotland. Thank you very much, and I hope next time that I'll be able to join the next SULI conference in person to be part of the discussion and to answer any questions which anyone might have.
Kirsty, it's a shame you couldn't be with us today, but thanks for doing that video at such short notice. And as Kirsty mentioned there, she's working as part of a team on the new edition of what was formerly the Law of Husband and Wife, and now renamed, probably more appropriately, it's 2021, the Law of Spouses and Partners. And again, it's one of the SULI texts that has been necessarily delayed, mainly by Brexit. So hoping that that will be finished and will be out at some stage within the next 24 months or so. So thanks again, Kirsty. And again, if you have any comments or questions for Kirsty, please put those on the chat. Finally, we have in this session Dr. Johnny Hardman. We've had a John, a Jonathan, and now a Johnny in this session, and another returner from the last event in Dundee. Johnny spoke there as well. Johnny's a lecturer at Edinburgh Law School. He was a solicitor in corporate finance practice for 10 years or so prior to moving to academy. And Johnny's research interests are primarily in the field of Scots commercial law, rights and security, and company law. And Johnny's going to talk to us this morning about how accessory is a guarantee. Johnny.
Thank you very much, Barry. There we go. Excellent. So good afternoon, everybody. So yes, my topic today is how accessory is a guarantee. I'm going to use the phrase guarantee and cationary obligations interchangeably over the course of this talk. So before we get into it, I should probably start by saying we all know and understand what a cationary obligation is, and we know that it is accessory, and therefore it's almost insulting. It's so axiomatic to Scots private and commercial law, it's almost insulting of me to raise this as a topic today. But I want to do so for two reasons, really. First, because it uncovered a couple of, it's an example of a couple of phenomena that I've seen throughout the topic of guarantees. And those phenomena are, firstly, artificial universalization, where we start with a specific aspect of a phenomenon and apply the characteristics of that aspect to the wider phenomenon as a whole. In the case of guarantees, we tend to be thinking of proper cationary obligations, guarantees that on their face are clear they're guarantees. And we tend to think of the characteristics of that and apply them to all guarantees, including improper cationary obligations, which are those that don't look like they're guarantees on their face, but are subsequently decided afterwards to be guarantees. So firstly, the first issue that this topic unveils is this false universalization. And the second is a slight vagueness of conceptualization, because we all know that guarantees are accessory. And again, accessory and ancillary tend to be used interchangeably. And we can all agree on that, but our individual understandings of what it means for a guarantee to be accessory are slightly different. So that's the first reason I want to discuss this topic, because it raises a couple of interesting phenomena that run throughout the subject. The second reason that I want to raise this topic is it was the first example of each of these phenomena that I uncovered in my research in this topic. So stark, so shocking was uncovering these that I actually had to stop on the project for a couple of months. I wondered, how can I be writing a SULI book on this if I can't even understand something as basic as the ancillariness of a guarantee? But when I came back, when I'd stopped hyperventilating and calmed down and came back and looked at it all again, I thought perhaps I was right. Perhaps instead there's a little bit of vagueness and false universalization taking place here. So guarantees are accessory. Everybody knows this, everybody agrees this. So if we look at McGregor and all on commercial law in Scotland, it states one way of distinguishing cationary from other similar obligations is that a cationary obligation is an accessory rather than an independent obligation, in that it always requires the presence of a principal debt. Similarly, Glogan-Henderson, a cationary obligation is an obligation which is accessory to a principal obligation. Now, I have responsibility for updating those two sections, and therefore it's perhaps not surprising that they back up the point I'm currently making. But in my defense, I didn't change any of that wording when I started doing so. Similarly, Paul McClelland in Scots Commercial Law, edited by Ian McNeill, says cationary obligations are said to be accessory to or dependent on a principal debt obligation. And in the Stair Memorial Encyclopedia, which has been recently updated by Ewan West, we have cationary obligations are accessory in nature, which means there must always be a principal obligation to which the cationary obligation relates. And these modern statements have important historical antecedents. Bell told us that cationary is an accessory obligation, and Glogan Irvin state a cationary obligation or guarantee is an obligation accessory to a principal obligation. And thus, we have this agreement. Everyone agrees that cation is accessory. And indeed, this is conceptually coherent. A guarantee falls under parts of our law of rights and security. It's a personal right in security rather than a real right in security. But rights and security conceptually are ancillary to a principal debt. They've been described by an Arizona court as being a tail on a cow. Whilst you can have one without the other, in this case you can have the principal debt without the security, you can't have the tail without a cow. You can't have the security without the principal debt. But even this unanimity in thought presents us with three questions. First, what do we mean by accessory? Second, are guarantees inherently and inevitably accessory? And thirdly, in what definitional way do we use accessoriness with guarantees? Do we use it to identify a guarantee, or do we use it as a consequence of a guarantee? In other words, do we use accessoriness as a way to differentiate a guarantee from other principal obligations? And the fact I've worded it that way lets you know the answer to that is yes. Or do we use it to say, once we've identified what a guarantee is, the effect of that is that it is accessory? So, firstly, is a guarantee accessory? So what do we mean by accessoriness? Now, luckily, we don't have to come up with our own definition. Andrew Stephen, in a piece in the Edinburgh Law Review on accessoriness in security over land, did so. He came up with 5 rules. Firstly, there must be a present debt. Second, there must be a specific debt. Third, the security must follow the debt. Fourth, the extinction of the debt ends the security. And fifth, that enforcement of the security requires indebtedness. And he states the fifth is the most important. And in fact, a standard security doesn't pass all of those tests. So how then do cationary obligations rank up against those tests? So first, future debts can be guaranteed. That's the case of Lakeman against Mount Stephen. There'll be nothing to sue for until there's an actual debt. So in a particularly narrow way, there's no real obligation until a principal of debt is constituted. But nevertheless, a guarantee can be created in advance of the debt that it constitutes. And Stephen said in respect of standard securities, because it is capable of securing future debts, the accessoriness principle is suspended, or perhaps more accurately, modified. Rather than securing an actual debt, it secures a possible debt. Nevertheless, like standard securities, guarantees can secure future debts, and as such, we fail the first test of accessoriness. The second test of accessoriness is there must be a specific debt. It's usual for guarantees, termed continuing guarantees, to apply to all sums due from time to time by a specific debtor in favour of a specific creditor. So examples of that, RBS against Brown and Veitch against National Bank of Scotland. And so these are, in the same way as guarantees for a specific debt, these are also guarantees, and therefore we can't say that the second test is inherent to all guarantees. Third, we have the idea that the security must follow the debt. In other words, if the debt is transferred so that it's owed to a new creditor, that the security will automatically go with it. Now, this is the default rule for guarantees under Waydale against DHL number 2, but there's some circumstances in which this isn't the case, 2 in particular. First, if there's an express term in the guarantee that says that the guarantee can't, the benefit of the guarantee can't be transferred to a new creditor. So that, thus, according to Anderson, that leaves the person holding a guarantee when he ceased to be a creditor, and thus the new creditor, the assignee, without the benefit of the guarantee. Assignation of the principal thus zaps the life from the non-assignable guarantee, but does not kill it. The second circumstance in which the guarantee won't automatically follow the debt is if there's some kind of delectus personae applies in respect of the creditor. In other words, if the guarantee wasn't given in respect of the specific debt, but instead in favour of a specific creditor. Whether that's the case or not depends on the transactional circumstances of the case, and that's promontory ram against Moore. So the default position is that the guarantee will follow the debt, but it's not inevitably the case that that will follow the debt. And also, if it doesn't follow the debt, that doesn't stop it being a guarantee, and as such, again, we can't say that this third test of accessoriness is inherent to every guarantee. Fourth, we have the idea that extinction of the debt ends the guarantee. Well, this is true if the guarantee is for a specific debt, and that's Aitken's Trustees against Bank of Scotland. In fact, even giving time or altering any other element of the principal debt, if the guarantee is for a specific obligation, will free the guarantor from that. That's C&A Johnson against Duthie. But in the same way as all sums guarantees don't need to relate to a specific debt, in the same way, there's no automatic discharge of a guarantee for a fluctuating amount if that amount happens to go to zero at any given moment. In that situation, the guarantee still continues for any future amounts owed until and unless the guarantor provides notice that it won't be done so under Buchanan against Maine. And as such, for continuing guarantees, which again are definitely guarantees, this fourth definitional aspect of accessoriness doesn't apply either. So fifthly and finally, we have the most important aspect, the idea that to enforce the guarantee, the debt itself must be enforceable. And that's the main test of accessoriness. So is this the case for guarantees? Well, here we have two directly opposing judgments on the matter. First, we have the 1836 case of Swan against Bank of Scotland. And that cationary obligation applied to any debit balances on a specific account. And the bank paid out amounts from the account, putting it into debit in situations which were illegal at the time. It was an invalid withdrawal, and therefore the bank had paid out, but the debtor wasn't effectively on the hook for that. And as a result, the withdrawals were void, and the case was about whether the guarantee itself was therefore also void. And in there, Lord Brougham said, now, if there could be no debt, there must be an end to the obligation to pay. And as such, we have a strident statement that, yes, this fifth element of accessoriness is ticked for cationary obligations. But then in 1872, a different case put us on a slightly more confused situation. That's Stevenson against Adair. So here we had a cationary obligation for the debts of a minor. I mean, somebody under age, not somebody whose profession was to be a minor. And the cationer knew that the principal debtor was under age. Now, under the strict accessoriness principle, the principal obligation was void, and therefore the cationary obligation should be void. But nonetheless, in Stevenson and Adair, the cationer was held to be on the hook for the debt, even though the principal debt was not enforceable. Now, in the judgment for Stevenson and Adair, there doesn't seem to be any reference to Swan against Bank of Scotland, which is quite interesting, and I had been hoping in the last year to get into the archives to see whether actually it was raised in proceedings or not. But sadly, I haven't been able to do so. So how do we reconcile these two diametrically opposed cases? Well, the Stair Memorial Encyclopedia, the original version drafted by Sandra Eden, points two potential ways to do so. Firstly, the cationer who knows that there's something wrong with the underlying debt is personally barred from somehow claiming that that wasn't the case. Now, I haven't been able to get to the library to have a copy of Reed and Blackie on personal bar, but my understanding is that personal bar can't be used to reopen an obligation once it has been terminated. And the authority I've got for that is Cantor's Properties against Swears Wells Limited. So if this is right, then this would preclude the operation of personal bar in this case and would mean that that wasn't in fact possible. Secondly, we could argue that cationary obligations cover what the parties intended to guarantee. And here again, knowing that the principal was underage and yet still entering into a guarantee arguably the Caishner agreed to guarantee the debt even if it were unenforceable. I think there's issues with both of those lines of argumentation structure. But whether you follow down those or different responses or different justifications, it doesn't really matter. The answer leaves us in a slightly confused position, and one which is inherently fact-dependent. And for our purposes, we can't say every guarantee automatically meets this fifth and key test of accessoriness that it needs the principal debt to be enforceable prior to being enforced. So, as such, not all guarantees meet the requirements of accessoriness. But let's presume they are for a second. Let's just pretend I haven't argued that things didn't work the way that we all know they do work. I want to explore, thirdly, the definitional inquiries aspect of this. Is accessoriness a definitional aspect of a guarantee, or is it an effect? Now, this hasn't arisen in previous discussion of accessoriness, because when it comes to standard securities, nobody is looking at a real right in a property and trying to work out whether it's a standard security or not by reference to whether it's accessory. In other words, there's no definitional aspect of it. The previous inquiries into accessoriness and real rights and security are purely limited to whether it's an effect of having that type of real right and security rather than definition. But when it comes to cationary obligations, we tend to use it as a definitional aspect. So thus we have in Scots commercial law, in theory, the distinction between a cationary obligation and a separate principal obligation is a simple one. It depends on whether the parties intend the second obligation to be conditional on the debtor's breach of the first obligation. In commercial law in Scotland, a cationary obligation involves guaranteeing the debt of somebody else. So if there's no debt of another person, there cannot be a cationary obligation. Glogan Irvin, cation is not an independent obligation, but is essentially conditional in nature, being properly exigible only on the failure of the principal debtor to pay at the maturity of his obligation. And in Stair Memorial Encyclopedia, as noted above, cationary obligations are accessory in nature, which means there must be a principal obligation to which the cationary obligation relates. As such, when we talk about cationary obligations, we use accessoriness, whether leaving aside the fact it might not apply, we use it as a definitional aspect. We use it to separate out a cationary obligation from another obligation, be it an insurance obligation, be it a representation as to credit, be it an indemnity or other principal obligation. It's this accessoriness principle we use to see whether it's a cationary obligation or not. And that would be fine if we didn't have improper cationary obligations. If we only had proper cationary obligations, that would possibly be an accurate, without any continuing guarantees, that could possibly be accurate. But we have improper cationary obligations which blow that out the water. So in an improper cationary obligation, it looks like it's a principal obligation, but it has characteristics of a guarantee and therefore is decided to be one. So in the case of Patterson against Bona, we had several parties agreeing a joint and several liability to a bank in respect of one specific account which only one of them could withdraw. And that was held in substance to be a cationary obligation, albeit an improper one. And similarly in Scottish Provincial against Pringle, we had several people entering into a joint and several obligation in respect of the amounts owed by us, loan due by us. But one individual, one of them had assigned their life policy to the life assurance policy to the bank, which would have paid off the obligation and the loan upon their death. And therefore it was held that really they had a principal obligation and everybody else's obligation was an improper cationary one. In other words, they were cationers in fact. So the issue here comes that we can't state that accessoriness is constitutive of cationary obligations, only that it's constitutive of proper cationary obligations to the extent that it applies at all. For improper cationary obligations, we have to look to the substance of the transaction. So we have to look to say, it doesn't matter whether it's accessory, instead we look to the substance, and if it is, we'll give you this accessoriness. But this is where the circularity comes in, because the only substance we have for a cationary obligation is whether it is, in fact, accessory. And therefore, we start by saying, we know you're not accessory, we'll call you a cationary obligation if we can find the core essence of a guarantee, which is itself accessoriness. And so, oh, sorry, I got a bit carried away, and my slides ran behind me a little bit. And so, in conclusion, we use accessoriness two ways for guarantees. We use it to identify proper occasionary obligations. It's definitional of the obligation. And we use it as an effect of improper occasionary obligations. But the definitional aspect risks obscuring what, at its core, occasionary obligation is. Oh, in addition, of course, accessoriness isn't actually inherent to occasionary obligation in the first place. So this leaves us in a bit of a quandary. Occasionary obligation texts use a concept that doesn't apply to occasionary obligations to spot one. They then say it doesn't matter if you don't have that, if you still fall within the category, if you meet our core requirements, which take us back almost exclusively to that concept. And if we find you have that concept, then the effect of that is that you are given ultimately that concept. The whole process of this identification is inherently circular and made so by improper occasionary obligations. So there's two takeaways I'd like to emphasize from this paper. First, these concepts all prove to be a bit slipperier than they first seem. The idea of a guarantee, it's a wider tent and needs to encompass more aspects than we have at our own head when we think initially about the concept of a guarantee. And similarly, our understanding of what accessoriness is tends to be a bit less precise. We tend to be quite keen to label things rather than necessarily look under the bonnet to see what exactly those elements of definitionally that label require. And secondly, and perhaps most importantly, this is why, Barry, it's taking me so long to finish this book. Thank you very much.
Yes, indeed, Johnny's at the early stages of a new SULI text on cationary obligations. Are there any questions from members of the audience, which could be very short, David, and succinct in one sentence? Thank you. Yes.
Thanks, Johnny. I wondered about the 5 features of accessoriness, and you said that they were derived from Andrew Stevens' article, and I just wonder, might the issues stem from these 5 features? Where did he get these 5 features from? Was it from, say, German law or some other comparative system?
Okay, so a question from David Cabrelli is asked about the 5 features of accessoriness that you derive from Andrew Stevens' work, and where in fact did he derive those 5 features from? Are they from German law or from some other comparative approach?
That's a very good question, and the beauty and danger of applying somebody else's work like this is that any mistakes they make or limitations on that automatically flow through to mine. His was a comparative study of rights and security, primarily focused on land, but with a slightly broader rights and security context, which includes occasionary obligations as personal rights and security. It mostly focused from German and civil sources, but it was a kind of comparative European approach taken to identify those core features. It is possible that those 4 features are indeed limited to real rights and security, and that they don't have application for personal obligations. But if that's the case, that raises an even wider question of what we mean by accessoriness in the context of guarantees. Because if those 5 features don't have it, what else, what other essences of accessoriness that we know is there isn't covered by those 5 features and that is somehow inherent in a guarantee? I think the conclusion is going to be that a proper cationary obligation and an improper cationary obligation are ultimately very different things, and that they fall within the same category, but that still leaves us with the issue, and one that I'm still grasping with, as to what exactly we use as the core of those wider grouped issues that means that we say an improper cationary obligation is somehow within the same tent, albeit differently, as a proper cationary obligation.
John Blackie, short question mediated through myself.
I wonder if you can use the Scots law unilateral promise that implied within negation of that minor
so it's quite separate.
Okay, so John Blackie has raised the issue about personal bar, and he wondered whether, in fact, the Incapax minor case could be explained by the doctrine of unilateral promise.
To an extent, yes. I think that certainly gives a direct claim from the creditor to the cationer. But I don't think it would be then correct to call it a cationer obligation, because then you've got a principal obligation come in that's breached. And so I think that's how you end up, if you're zoning out a second, I think that's how you reconcile that one is liable and one isn't. But I think it takes it outside the realm of cationer obligations, which gives us the same challenges for defining cationer obligations.
Yes, question. I think you can ask this directly without mediating. Thank you.
Following on from that, then, if the difficulty is identifying how accessory is a cationary obligation in the first place, doesn't it solve your problem in a sense to simply say, well, in this case, well, dealing with the cationary obligation at all, that one is outside of the tent and we don't need to think about it?
It would, were the judges not making statements. I think it was in a house. I think one of them's in a house, one of them's House of Lords. I think the Stevenson and Adair is in a house. It's treated as a cationary obligation there. So we can resolve it by stating ultimately that the court got that slightly wrong, and that instead it takes us down a slightly different route. So I suppose as a way of rationalising what the law should be, that works brilliantly. As a way of describing what we actually have in front of us, I don't think that quite ticks everything off. Now, it's entirely possible, given the vagueness that everybody has when looking at these concepts, and that's not meant as a criticism, that's meant as an observation around the criticism, because I went into it with exactly the same approach before started writing this book. It could be that all the sources can't actually be reconciled, and that actually what it needs is a slightly firmer voice of defining what a cationary obligation is and saying which cases are and which aren't related to that. That's a slightly different object of inquiry, a second stage, if you were, first of all, to try and see if everything can be reconciled, and if it can't, to then try to say how things should have been decided. Okay,
thank you. Great question. So I'm going to bring this panel to a conclusion by thanking Johnny. Johnny, as we know, is working on a SULI text on cationary obligations. Thank again Kirsty Hood for her presentation, which is part of their book, which is probably likely to come out in the next 2 years on the law of spouses and partners, and to John and Jonathan for their ongoing work on this. It's going to be a fascinating chapter, which will draw the law of Delict loose leaf volume to a conclusion. As I say, we'll have a celebration of that work in due course. Thank you very much. This afternoon we will be taking a break for lunch just now until 1:45. 1:45 we'll come back for panel 2, which is on judicial review and sentencing. We'll have a short break thereafter, simply for 15 minutes, and the final session between 3 and 4 will be on Scots criminal justice. Thank you. I can stop speaking slowly. I never do that in lectures. So
Okay to start? Yes? Great. Okay, well, welcome back, everyone. I think there's a bit of an echo going on here, is there? Is it just me? Okay. Welcome back from lunch, everyone, and hello to those of you who've just joined us. So this afternoon we have two sessions. The first is a joint one between Dennis Edwards and Stephen Thompson. Apologies, Dennis. Both of whom I think are known to the audience here. Dennis was formerly an academic at this very university, but he's now at the Faculty of Advocates, and I believe he's qualified both for the Faculty of Advocates in Scotland and also for the Bar in England and Wales. And he has appeared in the highest courts in the UK, including the Supreme Court. He's an expert in administrative law, public law, and law relating to education. Stephen Thompson is currently at the City University of Hong Kong, and he too is a specialist in administrative law, and his various books include one on the Nobile Officium. So they're going to be talking to us today about the effect of the recent pandemic, a topic very close to all of our hearts, I know, on judicial review. Over to you, Dennis.
Thanks very much, Pamela. So in the post-lunch slot on a Friday afternoon, it's obviously difficult to keep people's attention. So just to grab your attention, I'm going to ask you to bear at the back of your mind the case from 2 years ago on the prorogation decision, which was Cherry in the Court of Session and Miller 2, or Miller against the Prime Minister in the English courts. And as you will all remember, of course, the Supreme Court eventually decided that the prorogation decision or the advice given by the Prime Minister to the Queen, I'm never quite actually sure what it was. One thing or another, Parliament was not prorogued. And so what I'm asking you to bear at the back of your mind is what the standard of review was. What was the intensity of judicial review in that case? Now, I'm not going to answer that question unless you want a discussion of it, but I'm just going to ask you to bear that exciting case at the back of your mind, because clearly when we come to finish the second edition of judicial review, that's a big case. It's a big case on judicial review. It's a big case on review of the political prerogative powers. And we're going to have to come to a view on what the standard or intensity of review was in that case. Now, that's our theme. And Stephen is going to go on to pick up the specific title of our talk by reference to some recent decisions, I think 2 recent decisions, one in Scotland and one in England, on challenges to the COVID restrictions. And I think one of the concerns that we have, and what Stephen's going to talk about, is that we're not sure about what the standard of review or the approach to proportionality is in those cases. And I'm going to segue into that, if you like, with some general observations about the standard of review. And the takeaway is that what we need and what we're lacking is a structure of analysis for the intensity of judicial review. Now, debates about the intensity of judicial review are, of course, not new. It's been ever present in judicial review in every system that I know which has a system of judicial review, whether under a written, a codified constitution like in the US, or in our own system with, just common garden administrative law cases on common law grounds. The intensity of judicial review is something that's ever present. And 20 years ago, of course, it was inevitable when the first edition of Clyde and Edwards came out. It was inevitable, and we recognized that judicial review on human rights grounds was going to require more attention to be paid to what the intensity of judicial review is in particular cases. And proportionality requires that. Because, of course, proportionality, as an extension of irrationality review, takes the court into the field of the decision maker more intrusively than the other grounds of judicial review. And one of the features that I continue to very much be happy with in the first edition of Clyde and Edwards, and I claim no credit for it, it was very much Lord Clyde's analysis, is that we organised the grounds of judicial review, the discussion of the grounds of judicial review, basically according to the degree of intrusion into the decision maker's field, which was entailed by the particular ground. So we start with illegality, and in any system based on the rule of law, no one can object to review for legality, that the decision maker is asking themselves the right question and taking power where they have it and not rejecting it where they should have it. No one can complain about a correctness standard in that field. Either the power exists or it doesn't, and it's for the courts to say. But when we come to irrationality and proportionality, of course, at the other extreme, then things are more sensitive. Reasonable people can differ about what proportionality is, and we're in a much more intrusive field. And so as a proportionality and review for human rights has increased exponentially in the last 20 years, it's inevitable that more attention has had to be paid to the intensity of judicial review. And our theme, I think, is that this has now become a consuming consideration. And I can't say that all the reforms to judicial review procedure which have taken place both here and south of the border in the last 10 years are all because of concerns about the intensity of judicial review, but some of them certainly are. And that is definitely feeding in to some decisions of the courts. Now, in other systems, in particular Canada, every case, as I understand it, begins, certainly constitutional cases, but every case begins with the court asking itself, what is the structure of analysis which is to apply to this case? What level, and that then dictates, what is the structure of review? What intensity of judicial review are we to bring to this measure or decision? And that very much then dictates what the standard of review will be in the case. Now, sometimes it will be a correctness standard. More often than not, it will be a reasonableness standard. And then in constitutional cases where the starting point is a correctness standard, the intensity of review feeds in to how we are to understand the application of the proportionality test. Now, I think we are inching towards this. Up to now, my view is that we have not paid enough attention to structure of review analysis. And too often we have adopted rather simplistic approaches to these issues, if we've thought about them at all. So, for example, if we take asylum cases, every asylum case is supposed to attract anxious scrutiny, a term that goes back to House of Lords decisions in the 1980s. Now, many asylum cases, of course, justify anxious scrutiny, but many don't. And so I'm not terribly happy that every asylum case, by definition, always attracts anxious scrutiny. And the implication is that no other case can. I mean, that's a sort of standard approach to the way judicial review works. So an environmental case doesn't attract anxious scrutiny. Maybe it should. But as I say, asylum claims seem always to get anxious scrutiny. And the starting point would be no other cases do. Error of law. All errors of law are jurisdictional. Now, that's not the case in Australia or Canada. I'm not sure that Annis Minnick decided that. I mean, I've given up in trying to work out what Annis Minnick actually decided. But in England, certainly, the received wisdom by the 1990s on Annis Minnick is that all errors of law are jurisdictional. They can't be, right? In Scotland, like in other systems in Watt, there was still space for jurisdictional and non-jurisdictional errors. within the UK jurisdiction, Scots law was an outlier, but after CART in 2011, it seems to be that all, and certainly after Privacy International, all errors of law are jurisdictional. Again, now, for most of my life, I've believed what was wrong, and you might say, well, now having been vindicated after CART, I should be happy, but it turns out that I've changed my mind, and I now think what is right. All errors of law can't be jurisdictional, and this approach to simply saying all errors of law are jurisdictional is too rudimentary an approach. It's not engaging with the need for a more nuanced and a more structured approach to the intensity of judicial review. When it comes to human rights, of course, matters are even more difficult, and the courts have had difficulty getting the right intensity of judicial review in human rights cases. But in a very recent decision of the Supreme Court, what we might call the culmination of some of the austerity cases, we do get from Lord Reid, from a unanimous Supreme Court, a judgment authored by Lord Reid, what I think is, in terms of what we've had before, a masterpiece of analysis of the sort of a structure of a review analysis, what the analytical structure should be to decide what the intensity of review should be in proportionality. And the starting point is always to identify what the purposes of the relevant measure are. And in that slide there, I just show you the competing considerations. There were two different views. Now, to be clear, I'm not saying that having a structure of analysis will solve all the problems. It's not going to make judicial review any less contentious. There will always be big arguments about what the purpose of the decision or the measure is. But that has to be decided up front. It has to be decided early on the evidence. And once it is, then it will tend to lead to, it will tend to dictate what the structure of analysis is. And if you just flick through that quickly, you see that Lord Reid has synthesized, he's made a great attempt to synthesize the Strasbourg jurisprudence on when a wide margin of appreciation. And in the early days of the Human Rights Act, we were told, oh, let's not worry about this language of margin of appreciation, that's appropriate to an international court. Here we are 20 years on, and it is very much now coming up the rivers, as Lord Denning famously said about something else. It's very much in the domestic jurisprudence now. And when it's social measures, when it's financial decision-making, it's low intensity of review unless there is some countervailing consideration. And as you see in these quotes, even then, sometimes, even with fundamental rights being breached, suspect classifications, even then, there could still be, which would raise the intensity of review. There will maybe some other considerations which reduce it. We have here, it won't be the last word, but we have here, I think, something that is very, very useful in providing us a structure of analysis for the intensity of judicial review in cases with human rights elements. And I think it needs to move to the next stage of paving the way for a more structured, a more intelligible approach in every case to deciding what the intensity of review should be. And I think if we can do that, it's one way of assuaging concerns expressed widely and now acknowledged by the Supreme Court in this case, that judicial review has got to respect the limits of politics and the separation of powers. So it seems that we've got to have a clearer and more intelligible approach to the structure of judicial review, the structure of analysis, which will tell us what the intensity of judicial review is. And if we can get there, it seems to me we will put judicial review on a sounder and less controversial basis. And that's certainly something we're going to be working on. Now, I think COVID is going to bring this to a head because, of course, when you think about it, the COVID restrictions are in many ways restrictions of our most fundamental rights. And so it's somewhere where the starting point, you would think, would be quite an intense judicial review of the measures. But as we will see, things are not so clear.
Yeah, Dennis, excuse me, thank you very much for that. And I'm so glad that Dennis mentioned the separation of powers, because I think we have to be absolutely clear that's one of the maintenance of the separation of powers is one of the fundamental objectives in judicial review. And my concern as far as the COVID-19 pandemic is concerned is that if we look at some judgments, now I mentioned 2 judgments today, the English judgment in the Dolan case and the Scottish judgment in the Phillip case, being more critical of Dolan and more supportive of Phillip. But I feel that there's the potential here for the legacy of the pandemic on judicial review to be negative and to be damaging, because what I think we're seeing, especially in the Dolan case, is actually quite an alarming capitulation to government judgment and political judgment, and kind of cop-outs about, on a kind of deferential basis, and we need to grant them a wide margin of appreciation because they're listening to scientists and so on. If we look at Dolan, I think it's pretty bleak. I mean, there were all other kinds of problems with Dolan, such as I know from someone closely involved in the case that the oral transcript was lost and stuff like this during the case. There was no record of certain procedural hearings, and also that the case was stuck for a very long time, unable to progress to the next stage. Now, the Dolan case was a very broadly framed challenge, attacking the legality. And remember, this is about legality, it's not about anything else. Attacking the legality of the original restrictions in England related to travel restrictions, stay-at-home measures, and all the rest of it. And there were 3 main grounds there. There was a virus challenge, that the regulations which were made were ultra-vires of the Public Health Act of 1984, which a lot of people forget, in England at least, is the main piece of legislation which is relevant here, not the Coronavirus Act, as a lot of people seem to think, in England at least. Secondly, more admin law type grounds of challenge, fettering of discretion, irrationality, and so on. And thirdly, ECHR, human rights grounds violations. Now, the applicants were unsuccessful on all 3 grounds, and okay, fine, there's never anything predetermined about these cases, and they can always go either way. But what really jumped out at me was the complete departure from established principles of proportionality in this case. There's one short extract which really jumped off the page, and this was in relation to whether the restrictions were compliant with the Human Rights Act, ECHR, of course, being incorporated into the Human Rights Act. The court had said in relation to one of the grounds of challenge on a human rights basis, there can be no doubt that the regulations did constitute an interference with Article 8, but it is clear that such interference was justified under Article 8.2. It was clearly in accordance with law. It pursued a legitimate aim, the protection of health. The interference was unarguably proportionate, full stop. Since when is that the established law of this jurisdiction on proportionality? What happened? The first limb of proportionality assessment in establishing legality is indeed legitimate aim, the importance of the measure. Now, that's always going to be the least difficult for the government to justify, given the health challenges which are posed by the pandemic, and no one's going to underplay those. But we have nothing about the second limb here, which is the rational connection between the restriction imposed and the ultimate aim of those restrictions. We have nothing about the third limb, which is about whether a less intrusive measure could have been chosen instead. And we have nothing about the fourth limb, which is an appropriate balance being struck between the likely benefits of the restriction and the negative impacts, the detrimental impacts of the infringement on human rights. So, of course, that's not the whole judgment, but I invite you to go to the judgment, and you'll see the court says no more about that. And that's Article 8. It's a really important enshrinement of human rights in the legislation. The court there has completely departed from the established 4-stage proportionality test, which Lord Reid had confirmed in the Bank Mellett case in the Supreme Court in 2014. So that's immediately problematic. And it's alarming to see, again, given the fundamental nature of the restrictions on basic civil liberties here. And the courts, can reach different conclusions, but to not even apply the basic proportionality analysis, I think, is a real cause for concern. And it fills me with dread for future pandemics which are coming and future disasters, environmental, man-made, climate change, whatever, in terms of how the courts are going to deal with these issues. But there's more as well that I think gives us cause to be concerned and alarmed. One of the points the court kept coming back to in the Dolan case was to criticise the applicants for raising what it called academic issues. And they were said to be academic because the regulations kept changing. Now, you know, even those of us who've been most closely following this stuff from a legal perspective have had a really hard time keeping up with the latest regulations because they were changing on a weekly and sometimes even on a daily basis in relation to some particular areas. And the Court of Appeal, a 3-judge court in England, you know, comes out with, well, you know, why are you raising these points? They're academic. In addition to criticising the applicants for frequently amending the statement of facts and grounds, which was done precisely in response to the fact that the regulations kept changing. Now, this kind of reminds me in some ways of the contracting out problem with DataFin and all of that from the past, where the government can then try to find ways around legal accountability in judicial review. And if I was a government lawyer, I would be looking at that case and saying, so one of the ways around legal accountability in JR is just keep changing the regulations. Because this is what the courts are saying when the applicants struggle to keep up with this stuff. I think that is really a big cause for concern, in addition to other points as well, such as the court saying that we should be slow to interfere with decisions made after consultation with scientific experts. I'll return to that in a moment. So that's an English case which really, I think, was, really stood out, at least for me. I think there's been more hope, I think, in Scotland. The Philip case, which was decided by Lord Braid, and I'm very encouraged by Lord Braid's judgment by comparison to the Dolan court, because he did apply the 4-step proportionality test. Now, this was a challenge to the closure of churches in Scotland. Now, the judgment was only 2 days. It was 24th of March. It was only 2 days before the churches were actually going to be reopened anyway. But even he did not say, this is all academic because the churches will be open in a couple of days. He recognized it's better to deal with these issues now while they're before the court, rather than wait until the next time that human rights are potentially infringed and then to start getting into this. So he dealt with it. He did apply the 4-step proportionality test from Bankmillet. And he decided on his analysis that the 3rd and the 4th limbs were not satisfied and that the church closures were disproportionate and unconstitutional for that reason. Now, again, you can agree or disagree with his analysis, but that's a more faithful application of human rights law. So actually, the Scottish approach, I think, gives me cause to be a little bit more optimistic than what we saw in the Dolan court. But even then, and although I think Lord Braid's judgment is actually pretty good from a technical perspective, you still get the sense that there are some issues which have always been there, which once again come back to the fore, such as the question of whether the courts are really equipped to deal with complex scientific and technical information or data. So Lord Braid had said, for example, in that judgment that, and I don't want to be controversial here, but it's not in dispute that mitigating measures such as social distancing, face masks, etc., reduce the risk of transmission, and this emerges from, among others, Scottish Government advice. Well, that's fine, but there has to be a recognition there, and this is well documented, that the governments both at Holyrood and Westminster have been very selective in the scientific advice that they've chosen to incorporate. And again, I don't want to say anything controversial, but if you look at the government's own documents, the government's existing pandemic preparedness strategy at the very outset of COVID-19 pandemic is clear. Face coverings, there is no evidence, strong evidence, that face coverings reduce community transmission. Now, whether you agree or disagree with that, and this matter sadly has become ideologized and kind of moralized, the government's own position was that. Now, by the time of these two judgments, there had not yet been one randomized controlled trial study showing the positive effect of face coverings in COVID-19 transmission or SARS-CoV-2 transmission. Now, the question there is what changed? So it's not about my opinion about face coverings or your opinion about them. The government had radically altered its position, even although there had been no fundamental change in the scientific understanding, except according to the hand-picked scientists that were put on SAGE and NERVTAG and their devolved equivalents. And my concern here, and I don't blame Lord Braid or the courts necessarily for this, but the scientific evidence which is referenced is the government's version. Now, there are questions about how you would deal with that, and I don't claim that this is easy. I'm not quite sure how you get around that question. But the problem here is the cards all seem to be in the hand of the government. They get to dictate the scientific evidence. They get to dictate the pace of these proceedings, how often the regulations change, and so on. And so, again, although I'm more optimistic about the Scottish approach than the English approach here, I just don't think this bodes well for human rights protection. And my kind of closing word on this is to say that, you know, my own evaluation is to ask whether our human rights law is fit for purpose when you see judgments as in the Dolan case. Because this stuff takes a long, long time to build up. You know, democracy, respect for the rule of law, respect for human rights. And it's done incrementally and it's done through hard work. And it takes, you know, such little time for this stuff to be lost and rolled back. So I think, you know, if my or perhaps our contribution does nothing else, it's just to try to shine a spotlight on this and to try to make people who are not aware of this, you know, this is potentially a problem. So what will the legacy be? Well, I hope it won't be as negative as my kind of doom and gloom contribution has suggested. But I hope that there will be an evaluation which could be a more structured approach to intensity, perhaps, and reminding courts to apply the law, which is a good start for a court of law, in order to ensure that our fundamental human rights are fully protected. Thank you.
Gosh, so do you think there should have been more challenges then by the public to these rules? Surprising there weren't more than the ones that you've mentioned.
I mean, there have been more challenges, but then there are issues about who is bringing the challenges. Are they the right people? Do they have, you know, access? Do they get legal aid if they need that? And so on.
I mean, there have been a lot of challenges to procurement decisions, famously, the procurement decisions, many of which have been brought through judicial reviews to the procurement of PPE. But they are quite properly, the intensity of review would be a correctness standard, because Parliament, the legislature, has said what the rules are to be on procurement, on public procurement, and what the exceptions are. So it's quite proper for the courts there to say, well, is it right, is it wrong? Have you done it right, have you done it wrong? That's quite proper. But where you get into the discretionary field, whether on human rights ground or otherwise, and I think our concern, and I think what brings the presentations together is, in addition to wobbles in applying the established law and proportionality, I think what brings us together is a concern that we're clear about what the purpose of the measures is, or the decision is, and that we're clear about what that means for the intensity of review in light of what interests are affected. So most fundamental human rights, a higher level of intensity of review, as Lord Reid said in SC. But even then, the intensity of review can diminish if the government makes its case for there being other considerations, such as protecting fiscal resources, which are ultimately political, and the court's role should be less. That's more or less what Reid is saying in those passages.
Thank you. Okay, can I open up the floor? As this morning, if you have a question, please put up your hand. Try and make them short so I can repeat them for the people tuning in online. Who would like to start? David.
Hello, thanks for an excellent presentation. I found it fascinating because some of the work that I've done in the past is about intensities of standards review within the context of employment law. And one question and one observation. I think the question is your sort of plea for a more structured systematic approach that is that what is unusual, I think, about proportionality review, unlike, say, the rationality review, is that it's inherently in its DNA a fluctuating intensity of review. So it's not fixed. It really depends on the approach that the court takes in terms of what the aim is, and then in terms of the intrusiveness of the measure, I think. And I think that fluctuating nature of the intensity is what makes it quite difficult to pin down.
Yeah. If I could start with that.
Sorry, can I just repeat
Of course,
that for the
sorry,
people
yes.
online?
Yes,
So the first
sorry.
part of the question was, is your plea for a more structured approach to judicial review?
Well, the short answer to that is yes. And proportionality is limited to human rights and EU law, or retained EU law. So in the procurement decisions, for example, there would be a possible justification that it was done this way within the terms of the directive or whatever, and it was proportionate. So fair enough. But in all that, where human rights and EU law are not relevant, yes, I am still saying that we should have a more structured approach. And outside of human rights, there's two options basically. It's a correctness standard, or it's a reasons standard, a reasonableness standard. And I started with Miller, and I think at the end of the day, that when you look at it, once you've decided that the relevant power was reviewable, as to which I'm bound to say I think there are two correct answers, neither of which is reconcilable with the other. Once you've decided that, then clearly it was a reasonableness standard, because ultimately the court wasn't happy with the reasons that had been given for the prorogation. So yes, outside human rights and EU law, there should be a structural analysis. It should be made clear, what are we doing here? Is it correctness? Is it reasonableness?
Thank you.
Do you want to add anything? No.
Yeah. Okay.
I agree with that, yeah.
And the second part?
The second part, sorry.
Yeah.
What was your second question, David?
Well, it's really an observation about the nature of the proportionality standard itself.
Yeah.
And that is that it's inherently of a fluctuating nature. It's not fixed. It really gives the court a license to be less intensive or more intensive depending on the nature of the case. And what I understood you to be arguing is that we don't really have any guidance as to why, apart from this judgment.
Well, I think they're struggling with it. They've been struggling. They've been struggling for some time, and the austerity cases have brought matters to a head, a series of those. And I think COVID is going to continue this. But SC does give us some insight into the flexibility of proportionality. And like in other judicial review contexts, it's more or less a reasonableness standard. When, with less intense review, when certain political matters are before the court. But the standard can be adapted to be more intense. In that last passage there, I highlighted a number of words there, which is the appropriateness of the ordinary approach to proportionality, and I'm not completely clear what that means. And so there's a bit more work to be done here. I mean, this is a great start, but there's just a little bit more work to be done about what exactly the appropriate standard is with the ordinary approach to proportionality. I mean, I'm not quite sure what the ordinary approach to proportionality is. I mean, I would say the ordinary approach to proportionality is quite intense review. So there's a bit more, but it's getting set. Everyone will benefit. The courts themselves, the lower courts, advocates, and academics will ultimately benefit if it's clear what we mean by the appropriate intensity, or what flexibility the test is to be applied to.
Yeah, I mean, just to add one further point on structure, something that I kind of noticed and interested me was that proportionality challenges to various COVID restrictions, which, you know, have been of a similar nature in many countries, many European countries, have tended to be more successful in the civil law jurisdictions. Now, I haven't looked into that in great detail, but I wonder, you know, they tend to be more structured in their approach to questions like proportionality, including being guided by a codified constitution, which we don't have. Which, I mean, that I think arises again as a question, does there need to be some more fundamental law on that? But actually the Human Rights Act is meant to be a more fundamental form of law anyway by which to gauge the legality of other legal acts. But, you know, even in countries like France, Germany, Austria, Czech, you know, these countries have all got judgments where restrictions, curfews, for example, in France, were in several departments within France were struck down as disproportionate. And I just wonder if there's some correlation there, because, you know, the common law is kind of always talked up as well. You know, you can apply all these kind of approaches to reasoning and it's not quite so kind of mechanical, but actually is mechanical the right way to think about it? Because if you apply that 4-stage proportionality test, I think it is quite actually a helpful way of, you know, you start actually with the easier stuff. Is there a legitimate aim? Well, of course there is. I mean, you're trying to reduce incidence of death or serious illness, and then it gets more difficult for the government as you move down. But that then provides you with the framework within which to adjust the intensity in a non-arbitrary way. The problem is if you then depart from that, which a 3-judge court has done in England, and actually one of the reasons I contrasted these two cases is that one is a 1-judge court in Scotland and the other is a 3-judge appeal court in England. Usually you get kind of, I don't want to say better judgments, but you do tend to get better judgments from more senior courts with more judges on them. It's just I guess it's a fact in many cases. And so I think that does provide a framework. I agree with Dennis, there's more to be done. But it just kind of, I think it brings to the fore the importance of having this structure, even in a common law system.
Okay, great. Thank you very much. Thank you. So now we're going to move on. I think we have a recorded session next from Dr. Graham Brown from the University of Durham. And Dr. Brown is an assistant professor of criminal law there. He was a professional support lawyer for the Scottish Criminal Appeal Court for 13 years before he became an academic. And his books include a couple of works on sentencing, Sentencing as Practical Wisdom, and another one looking at comparative sentencing in rape cases.
Well, good afternoon and pre-recorded greetings from Durham. Now, I'm sorry that for family reasons, I can't attend in person, but nevertheless, it's still a pleasure to be able to speak to you today about sentencing law and practice in Scotland, and in particular about the SULI title on sentencing, on which I'm currently working. So I'll begin with a few words of introduction. So a bit about me. I qualified as a solicitor 20 years ago. After a few years working in judicial training for what's now the Judicial Institute, I spent 13 years as a professional support lawyer to the Appeal Court, working under the direction of the Lord Justice Clerk. It was during this time that I developed a particular interest in sentencing. Now, this led to my undertaking a part-time PhD at Edinburgh University on sentencing law, theory and practice, and on judicial decision-making in sentencing. I received my PhD in 2014, and since 2018, I've been a full-time academic at Durham Law School. My research involves the use of social theory, legal philosophy, and a comparative examination of case law from various common law jurisdictions to research, interpret, and analyse the task of sentencing generally, and the sentencing of specific offences also. I've published 2 research monographs on sentencing in 2017 and last year, the book on sentencing rape. And I also regularly contribute to Green's Criminal Law Bulletin, where I provide commentary on important decisions of the appellate courts on sentencing law and practice. Now, in today's presentation, I'll provide some background to this area of law. I'll then look at some important recent developments,
and conclude by discussing the SULI book on sentencing. So there's a quote attributed to a New Zealand judge, Justice McCardle, that trying a case is as easy as falling off a log. The difficulty comes in knowing what to do with an accused once they've been found guilty. Now, I'm not entirely sure that I'd agree that trying a case is in fact that easy. However, it's certainly the case that sentencing law and procedure has got a lot more complicated in recent years. Scottish judges and sheriffs have traditionally enjoyed a very wide sentencing discretion, and the appeal court was slow to issue any form of sentencing guidelines. In 1992, the late Sheriff Principal Gordon Nicholson published the second edition of what remains the most comprehensive analysis of what might be called the general part of Scottish sentencing law. Now, His Lordship reported in this volume that it was customary for the appeal court to say no more than was strictly necessary for the disposal of the particular case. The appeal court had always adopted what Nicholson described as a pragmatic and individualised approach to questions of sentence. And cases were decided on their own facts and on their own circumstances, rather than being based on any declared principles. Now, things have moved on since the early 1990s. The appeal court and the sheriff appeal court have the statutory power to issue sentencing guideline judgments. That's under the relevant sections of the Criminal Procedure Scotland Act. Guideline judgments are judgments of appellate courts which go beyond the facts of the particular case before the court by articulating sentencing principles, and this can be done by considering numerous variations of a specific offence, perhaps the importance of aggravating factors and of factors commonly raised in mitigation, also by discussing the relevance of different sanctions to the particular offence, or perhaps by suggesting appropriate sentencing ranges. Now, in Scotland, the principal objective in issuing guideline judgments has been to structure, but not to restrict or abolish judicial sentencing discretion. The number of formal guideline judgments issued by the appeal court has increased substantially in recent years. They tend to be issued in relation to offences about which there is public or political concern, and there are a few examples up there on the slide. So it includes cannabis farming, offences involving child pornography, or child sexual abuse images, sexual offences committed in breach of a position of trust, and guideline judgments have also been issued to ensure consistency of approach in the lower courts. Now, the best example of this is the series of guidelines on the practice of guilty plea discounting. These guidelines were first issued in Deploy. They were later developed in Spence. However, due to the inconsistent manner in which the guidelines were implemented in the lower courts, they were later refined and clarified in the decision in Gemmell, which remains the leading authority. A formal system of numerical, presumptively binding guidelines operates in England and Wales, and these guidelines are issued by the Sentencing Council for England and Wales. Courts must follow the Council's guidelines unless the court would be satisfied that it would be contrary to the interests of justice to do so. And in fact, the previous Lord Chief Justice has remarked that the English sentencing system now proceeds on the basis of guidelines, not case law. Now, whilst these guidelines don't apply in Scotland, the appeal court has stated in a number of recent decisions that Scottish sentencers can use the sentencing ranges contained in English guidelines as a comparator and as a form of cross-check to see if any major disparity arises. That's the decision in AB. Now, while this effectively results in Scottish judges proofing their sentences against those imposed by the English courts, the appeal court has also cautioned against applying English sentencing guidelines in a rigid fashion or in a mechanistic fashion. That's the decision in Geddes and most recently in Gatti. My own research has demonstrated that it's questionable whether judges do actually have regard to relevant English guidelines as a form of cross-check, certainly at least in the sentencing of rape. So sentencing guidelines then have been used by the appeal court either to guide judges and sheriffs onto the path of consistency in approach, or to ensure that disposals are proportionate to the nature and seriousness of the offence in question. Another important development is the establishment of the Scottish Sentencing Council. The Council is an advisory body chaired by the Lord Justice Clerk, established under sections 1 to 13 of the Criminal Justice and Licensing Scotland Act 2010. The Council has been operational since 2015. Now, it's tasked with promoting consistency in sentencing, assisting in the development of sentencing policy, and promoting greater awareness and understanding of sentencing policy and practice. The Council has a statutory duty to prepare sentencing guidelines for submission to the High Court for its consideration following a period of public consultation. The High Court can either approve or reject the Council's proposed guidelines in whole or in part, with or without modifications. That's under the relevant sections of the 2010 Act. If the High Court does approve guidelines submitted by the Council, then all courts are required to have regard to them and to state their reasons if the guidelines are not followed. So unlike the position in England and Wales, these guidelines do not have a binding status. This ensures that the principle of judicial autonomy in relation to sentencing is retained. Now, despite having been operational for almost 6 years, the Council has only produced 2 guidelines, both of which were approved by the High Court. The guideline on the principles and purposes of sentencing came into effect in November 2018. The guideline establishes proportionality as the key sentencing principle, and it lists the standard purposes of sentencing. So public protection, punishment, rehabilitation, reparation, and denunciation. The guideline uses non-technical language throughout, and it was clearly drafted for the benefit of the public rather than for the judiciary or the legal profession. The guideline essentially restates principles and purposes that are already well understood by judges and practitioners, albeit in terms that are readily understood by the public. Moving on to the latest guideline from the Council, the guideline on the sentencing process. This was approved by the High Court in July this year, and it will come into effect across all courts in Scotland on the 22nd of September. The sentencing process guideline is aimed at increasing public knowledge and understanding of sentencing. It sets out an 8-step guide which courts should follow in order to reach a sentencing decision. Now, in terms of the guideline, sentencers are directed to take the steps that are up on the slide there. So assess the seriousness of the offence by reference to culpability and harm, select the sentencing range using any specific guidelines that there might be, either from the Council itself or from the appeal court, identify aggravating and mitigating factors, determine the headline sentence, and then take into account a plea of guilty. The judge or sheriff then has to consider time spent in custody by the offender. He or she is to consider any ancillary orders and then pass the sentence and give reasons for it. Now, importantly, this latest guideline acknowledges the sentencing decision may be made very swiftly, and in many cases, the court may appear to consider some or all relevant factors at the same time. What the guideline says about it is this: when a court does not expressly take any individual step, that does not in itself amount to a decision not to follow the guideline. A court may choose to explain aspects of a sentence it has passed by reference to a specific part of this guideline. It does not have to give full reasons as to how each part of the process has affected the sentence. So this makes it clear then that an appeal against sentence cannot be based on a supposed failure by a judge or sheriff to follow this guideline. And it also illustrates the fact the guideline is, once again, intended primarily for the benefit of the public rather than for sentencers or for the legal profession. So moving on then to the SULI text on sentencing, my proposal for this book was accepted by the Council earlier this year. I submitted the proposal following discussions with both the judiciary and the legal profession. As a result of these conversations, it was clear that there's a pressing need for an up-to-date, comprehensive and authoritative text on sentencing law and practice in Scotland. Defence agents, for example, noted that there's no modern textbook to which they can turn to assist them in preparing pleas and mitigation, in preparing sentence appeals, or to guide them generally through the sentencing process. Judges and sheriffs, meanwhile, remarked that they would also find a practitioner text on sentencing extremely useful. Judges have suggested that such a text is required due to the complicated and technical nature of sentencing, together with both the increasing numbers of appellate judgments that deal with sentencing issues and also guidelines issued by the Sentencing Council. Now, added to this is the fact that the profile of the professional judiciary in Scotland is changing. Many appointees to the bench, particularly, although not exclusively, the summary Shrivel bench, have practiced mainly in civil law and have little or perhaps no recent experience of representing clients in the criminal courts. Just as an example of this, I recently spoke to a senior member of the criminal bar, and this individual reported that some sheriffs haven't heard of Kane. Now, this is a reference to the decision in Kane against Her Majesty's Advocate, which emphasised the importance of rehabilitation in sentencing young offenders. And this decision has led to a series of appellate decisions on the sentencing of young people. Now, it can certainly be difficult to keep up to date with developments in what has become an ever more complicated and fast-changing area of law. Nevertheless, the fact that some sentencers are unfamiliar with certain leading cases is concerning. The recent decisions of the Sheriff Appeal Court in Hepburn and Donnelly, Donnelly being a Crown appeal against sentence, are also a bit worrying, it has to be said. Both Hepburn and Donnelly demonstrate fundamental misunderstandings of really fairly basic sentencing procedure by the summary sheriffs concerned. Now, a comprehensive SULI text on sentencing will, I hope, go a long way to addressing these problems. In its final report, published in 2006, the Sentencing Commission for Scotland noted that there are a very limited number of up-to-date analytical textbooks on sentencing practice. Now, the Commission recommended that the Faculty of Advocates, the Law Society and the Scottish universities should consider encouraging and commissioning academics and practitioners to produce more textbooks on sentencing. Such texts would, it was suggested, be of practical assistance to sentencers and to others involved in the criminal justice system. After 15 years, however, no such textbooks have emerged. And in writing Sentencing Law and Practice, I aim to address this. The book will be published in 2 volumes. Volume 1, Principles of Sentencing, will deal with the broad themes and principles of sentencing theory and judicial decision-making in sentencing. Volume 2, Sentencing Practice, will examine sentencing practice for specific offences in detail. Now, Volume 2 is likely to require regular updating. Once it's published, I intend to prepare regular updates. And in due course, I'll look into the possibility of working with the publishers to make these updates available, perhaps on Westlaw. So the book will provide an up-to-date explanation of contemporary sentencing law and practice in Scotland. It will provide sheriffs, judges, solicitors, advocates and others involved in the criminal justice system with a comprehensive and reliable guide to and analysis of Scottish sentencing law, procedure and practice. Volume 1 will provide an in-depth discussion of the sentencing process and the nature of judicial discretion in sentencing. It will then proceed to provide an authoritative account of the rules governing particular disposals as set out in statute. So that would include custodial sentences, non-custodial sentences, and incidental disposals. Having considered the relevant statutory provisions on sentencing, the book will then provide an in-depth discussion of sentencing principles by reference to relevant appellate decisions. So this part of the book will focus on issues such as aggravating and mitigating factors, the sentencing of young offenders, and the operation of the guilty plea discount. Volume 2 will consider sentencing practice for certain particular offences, including sexual offences, road traffic offences, drug offences, firearm offences, assault, and offences of dishonesty. These chapters will focus on guidance and statements of principle developed through case law by the Appeal Court and the Sheriff Appeal Court. The book will analyse all recent legislation, case law from the appellate courts and guidelines from the Sentencing Council and will explore their implications for sentencing practice. Although considered in the main text, specific sentencing guidelines issued by the Council, by the Appeal Court and the Sheriff Appeal Court will be included as appendices for ease of reference. My previous monographs on sentencing have provided comparative analyses of sentencing law, theory and practice by considering sentencing practice in jurisdictions such as England and Wales, the Republic of Ireland, Canada, Australia, New Zealand and South Africa. Sentencing law and practice will also employ a comparative approach where appropriate. Now, to my mind, this is a particularly important aspect of the book because sentencing is one area of law and social policy that lends itself particularly well to comparative treatment. Now, although structures and laws can vary from one country to another and different terminology may be used, essentially we're all struggling with the same fundamental questions. So why do we punish? What range of penalties should be available to the sentencing court? When is a custodial sentence appropriate? And how should judicial discretion be structured? Delivering the Judicial Institute lecture back in 2016, the former Lord President, Lord Gill, noted how Scottish criminal law, procedure and sentencing have developed through an increased willingness to learn from other common law jurisdictions. In particular, his lordship remarked upon the trend in recent years for the appeal court to consider sentencing guidance from the courts of England, Canada, Australia and New Zealand, along with academic and research literature in issuing its own sentencing guidelines. This, his lordship suggests, is evidence of the new internationalism of Scottish jurisprudence, in which an open-minded High Court is prepared to derive every possible benefit from good law and good theory that is available in other jurisdictions in the English-speaking world. So, with in-depth coverage of both general principles and sentencing for specific offences, it's my intention that the book will be a comprehensive and authoritative source for practitioners and for the courts. I intend it to become the standard reference work for all sentencing issues in the Scottish criminal justice system. Well, thank you very much for your attention. Again, apologies that I can't be there in person to answer questions. However, my email address is up on the slide there, and I would be very happy to discuss any aspect of the project with you. Thank you.
Okay, well, thanks everyone. I think that it very much looks as if it's going to shape up to be the seminal work on sentencing. If you do have questions for Dr. Brown, do put them in the chat or email him as he suggested. We're going to have a short break now. We'll resume again at 3 o'clock, prompt, and we'll see you all again then. Thank you.
for joining us for our final session today, which is on Scots criminal justice. Today, we have in this final session, we have our two live speakers, so no pre-recordings for this final session. Up first, we have Professor Pamela Ferguson, who's the Chair of Scots Law at the University of Dundee. And her main areas of interest are criminal law, criminal procedure, and she's currently preparing the SULI textbook, Scottish Criminal Procedure. And this afternoon, she's going to deliver her paper, Scottish Criminal Procedure, Developing a Normative Framework. Thank you, Pamela.
Thank you, Michelle. So the last time I think I gave a paper face-to-face in person, it was the last SULI conference in August 2019, 2 years ago, almost to the day. I have given papers since then at workshops and conferences, including one at a conference in Hanoi. But I was safely ensconced in my own home, in my office at home, rather than travelling to Vietnam for that one. So this is the first time I've been able to talk to people face-to-face in person. Which is fantastic, but also slightly strange, I have to be honest. So the paper I gave 2 years ago talked about what I was hoping to do with the book I'm writing on Scots criminal procedure. And I commented at that time that I was aiming to produce a book that not only described the black letter law, but which was also critical, theoretical and comparative, but with the emphasis on the critical. And at that time I talked about the fact that I was going to try and develop a kind of normative framework in order to critique Scottish criminal procedure, but I wasn't entirely sure how to do that, and I talked about some of the models that I might use, other people's models really. Since then I've been trying to develop my own framework and come up with a system of values and rights that I think any system of criminal procedure should embody, and then try and see to what extent Scottish criminal procedure maps up to that. So the values I've come up with so far, and this is still a work in progress, are that really we should be looking to find procedural fairness, respect, a system that safeguards people's dignity, promotes equality, upholds autonomy values, and within that we've got privacy, bodily integrity, physical freedom, the ability of parties to control the procedure themselves, to participate in the procedure effectively, etc. And of course, waiver, it's very important that you can waive your other autonomy rights. And for most of these values as well, they focus on the individual. How does that impact on the suspect or the accused or witnesses or victims or whatever? But we also have public interest values which apply to persons more generally. And so the ones I've classified as the public interest are things like public safety, efficiency, including whether things are done swiftly and appeal processes come to an end at some point, process integrity, predictability, are things transparent, are things rational? So these are the values, and then as well as the values, my taxonomy looks at a number of rights, and I've grouped these into the 5 headings: foundational rights that apply to everyone, pre-trial rights for suspects and accused persons, trial rights, post-trial rights, and then rights for victims and other witnesses. And in trying to get these this rights framework, I've drawn on quite a wide variety of sources. So I've looked obviously at things like the European Convention of Human Rights, the International Covenant on Civil and Political Rights, but also at things like the US Bill of Rights and judgments from the US Supreme Court, Canadian courts, EU directives, that sort of thing. So the idea is to have this normative framework, as I say, which I then say, right, okay, this is what we could have in terms of rights. Now, what rights does Scotland recognise? Are there any rights that we recognise that we maybe shouldn't recognise, or any rights in my framework that Scotland doesn't recognise but ought to recognise? So I think I've come up with about 74, 75 rights altogether so far. I'm not going to look at them all today, you'll be glad to hear. I'm really going to focus, just give you a kind of whistle-stop tour of the rights, and then focus on the ones that relate particularly to the police, since that's the chapter I've been working on for most of this summer. So foundational rights, there's quite a list of them there. The 2 that I've highlighted are the ones that map onto the police most particularly. So obviously, the right for all of us, foundational rights as they apply generally to everyone. We should all be free from arbitrary searches or seizures of our property, from arbitrary arrest, detention and other deprivations of liberty. Other ones there are obviously very important, such as unwarranted discrimination on the grounds of race, religion, sex, sexual orientation, etc. But the 2 in blue are the ones that map onto the police in particular, and I'll be speaking about the police, as I say, later on. Then we come on to quite a slew of pre-trial rights which relate not just to persons generally, but are more specifically for suspects and accused persons. And the first one of these might be seen as rather odd to be treated in a way that corresponds to the presumption of innocence, because you might think, well, hang on, that's not pre-trial, that's the trial. And of course, people generally treat the presumption of innocence as being just another way of saying the onus of proving guilt is on the prosecution. It's not for the accused person to prove their innocence. But in the book, I suggest, and I've argued this elsewhere, that it should also be treated as a mindset, as a sort of practical attitude that permeates the entire process, so that all the players, police officers, judges, prosecutors, even pre-trial, should approach suspects with the presumption of innocence in mind, keeping in mind that they're not dealing with someone who's been found guilty at that stage. More pre-trial rights here, quite a number of them. The ones again in blue are the ones that I want to focus on. All of these really are to do with suspects' interactions with the police, but the ones in blue I'll come back to: pre-trial identification procedures, a fair police interview process, recording of police interviews, and being cautioned that you have a right to silence when you're being questioned. Trial rights, and again, I'm not going to, you can kind of read them or at least have a quick flick at them just to get a sense of them. These are, if you forgive the pun, the usual suspects. They're the kind of things that you'd expect to see: trial rights, fair trial, public trial, independent and impartial tribunal, etc. Some of these, if you look on the right-hand column, some of these touch on evidence law, and of course it's a balance in the SULI book about whether I should include certain things as part of criminal procedure or whether they are in fact more about the law of evidence. And of course there is already a very good book by Fraser Davidson on the law of evidence, and I don't want to duplicate that. A controversial right is the one that's, I think it's, is it fourth from the bottom on the right-hand side, to be able to examine prosecution witnesses. And that, of course, is a good example of what I said before about the fact that some of the rights on our list we might not want to recognise. So if you give an accused person a right to personally cross-examine a complainer, that, of course, has implications for the rights of complainers to be treated with dignity and respect and that sort of thing. And another example which is on the list that we don't currently have is the bottom one, a reasoned judgment. At the moment, of course, juries don't give reasons, and that's there so that the book will explore the debate about whether juries ought to give reasons or not. They don't give a reason for the verdict. Should they? Perhaps they should. Post-trial rights, again, these are fairly self-explanatory. They mostly deal with people who have been convicted. But even if you're acquitted, you have a right to the benefit of the presumption of innocence, and that again ties in a bit with the police, because we don't want the police saying they're not looking for anyone else in connection with the case, which is they often sometimes say when people are acquitted. The presumption of innocence suggests that nothing should be said which leaves a kind of aura of suspicion on the person who's been acquitted. And again, here we have some that are not fully recognised by Scots law. The penultimate one on the list, not to be tried for the same crime twice. We have got encroachments on double jeopardy in Scotland. And then we come on to rights for victims and other witnesses, and again, I'm not going to say anything about them today. I haven't written that chapter at all, but all I've got so far is to say here are a number of rights that might impact on victims and witnesses. And you can see, of course, the potential for the clash of rights between those of suspects and accused persons on the one hand and those of victims and witnesses on the other. So once I've got that normative framework, and as I say, it's there in draft form, but I still have to do a bit more work in it, I'm then going to map that onto the various parts of the system: the police, the prosecution, the trial, etc. And what I've been working on this summer has been the police chapter. So as you can imagine, lots of the values in the normative framework do have relevance to the police. They should treat people fairly with respect, dignity and equality. And when I mentioned this to a colleague actually a few weeks ago, they said, why are you including things like dignity? You'll be hard put to find a Scottish criminal case where the appeal court have said anything about anybody's dignity. That's not something that's a concept we deal with. But actually in police documents, there's a lot of references to dignity and equality. So in the Stop and Search Code, in the police standards of professional behaviour, in the constable's declaration that they swear on oath when they become a police officer, they talk about things like respect, dignity, equality, etc. Autonomy, obviously, autonomy values are very much jeopardised or at risk of jeopardy when the police engage in their powers of stopping, arresting, etc. People. The public interest, one of the ones there we mentioned was efficiency, and it's quite interesting to see that the efficiency seems to have been the prime motivation for the creation of one Scottish force in 2013 when Police Scotland was created by the amalgamation of the 8 other forces. The real drive for that was an efficiency concern to save money. But of course, efficiency is not an unalloyed good. And so within that, I'm going to also be looking at the case of Lamara Bell, the woman who died in a road traffic accident outside Stirling in 2015 and lay dying in her car for several days before the initial police call was followed up. And an independent review found that the delay was due to financial cuts in the centralised police call handling system. So that's an example of an efficiency not working to the public good at all, not in the public interest. Transparency, another public interest concern here, and under that heading I'm going to look at things like police use of drones, police use of body-worn cameras, both of which of course also raise privacy concerns. And within transparency I want to look at police misconduct, what happens when the police are accused of either breaking the criminal law or acting in another unprofessional way. And transparency also I think we can see in the setting up of the independent advisory group chaired by John Scott QC, which was to look at the police use of the powers, their emergency powers in the pandemic. The very fact that the Chief Constable set up that advisory group I think shows you that the police are concerned to be seen to be acting in a transparent fashion. So when we turn to process rights, I mean, as you can imagine, most of the rights that were on my earlier lists that we ought to have, Scots law quite happily ticks the box for these. But not all of them. The ones I highlighted in blue are the ones I have some concerns about. And one was that I posed this right of having pre-trial identification procedures which are conducted fairly and in conformity with statutory guidelines. And currently we have Lord Advocate's guidelines. They're not statutory, they're just unofficial guidelines. And the appeal court said quite a few times, well, they're just guidelines, so the police don't really have to follow them. But the Bonamy Committee, the Post-Corroboration Safeguards Review, which reported in 2015, recommended that unofficial Lord Advocate's guidelines be replaced with a statutory code of practice. And so the Criminal Justice Scotland Act 2016 had a provision that said the Lord Advocate must produce a code of practice. And that code of practice has now been drafted and circulated for public consultation. That was done in May this year. However, I think the draft falls short, I'm afraid, in some respects. So, for instance, there's no requirement for double blinding. So the idea there is that the police officer who's conducting the parade, whether it's a live parade with real people standing in and one of them's a suspect, or whether it's a video online parade where the witness looks at an array of photographs of people, one of whom is the suspect, double blinding is the idea that the police officer conducting the parade shouldn't know which of the people is in fact the suspect. The witness should just come in and say it's number 3, that's noted down by the officer, and then we see somebody else checks, well, was that the suspect or did they pick the wrong person? And that's it. There's a lot of psychological literature on that which suggests that if you don't go for double blinding, you can get subconscious bias where, the officer just, sighs when you get it wrong or smiles when you get the right person. And of course, unfortunately in Scotland, we've had cases even of conscious bias where police officers have said to witnesses, you didn't do very well there, did you? So double blinding would prevent that. The literature suggests that it really is an important safeguard. It's not something in the current draft code, and I think that really should be changed. On my list of potential rights, we also had one of the right to having fair police interview processes and to have the interview audio-visually recorded. And as with the pre-trial identification code, Bonamy also recommended that we have a statutory code of practice governing the questioning and interviewing of suspects in police custody. And the draft code was published by the Crown Office at the same time as it produced the draft identification code in May this year. The idea of the code is that it will make clear what the police ought to be doing. The courts will then take that code and the other code, they can take them into account in assessing practices, and they provide safeguards to suspects saying that these should generally be audio-visually recorded, these interviews, and that the caution should be administered to suspects prior to interview, etc. However, this is paragraph, I think it's 1.15, 115 of the draft interview code, and it starts by saying an interview is the questioning of a person regarding their involvement or suspected involvement in a criminal offence or offences. So far, so good. However, it then goes on to say that for the purposes of the code, it's not an interview if the questions are designed to establish if a crime has been committed and to determine if there are reasonable grounds to suspect that a person committed the crime, which seems, I thought, to be the whole point of a police interview. What else are you doing if you're not trying to work out, has there been a crime and did you commit it? It also says that it's not an interview if the questions are designed to establish if the person is entitled to rely on any statutory defence or if they want to put forward any exculpatory information. And again, I don't really understand that either. You know, if you think, for example, of the case, there was a case of Her Majesty's Advocate against Hawkins a few years ago, where the accused was suspected of having raped somebody. In the course of that interview, the police would ask the suspect, you know, did you have sexual intercourse with the person that's complaining that you raped her? Surely that's a question designed to find out if a crime has been committed and if the accused committed it. That's fine, plenty of time. And then they also would say, well, if he says, oh yeah, we did have sex, they would then say, well, did she consent? Are you saying that she consented to this? Surely that's designed to find out if he's got a defence or not. That's what I would call a police interview. So it's extremely odd that these are defined as not being interviews. Perhaps it's just, I was going to say sloppy wording, I should probably be a bit more circumspect. It could be worded a little bit more precisely. Maybe what they meant to say was something like, it's not an interview if the question is limited to establishing a defence, so they're only asking you about a defence or something. But it's not clear why they've used this form of wording. If it's not an interview, the protections of the code don't apply. One of the protections is the caution. I think the caution is actually really badly worded that we have in Scotland. You are not obliged to say anything. It'd be much better to simply say you don't have to answer if you don't want to. You know, we should really simplify these things for people. But even these protections are not available if the code doesn't apply. And if you define these things as not being an interview, then you lose the protections of the code. So that's the sort of things I'm going to be looking at in the police chapter, trying to map the rights and the values against current police practices to see to what extent Scotland measures up. So I hope that's given you a flavour of the book and of the police chapter in particular. I'm happy to answer questions about either the book's general structure, the rights, the values, or the police stuff. Thank you very much.
Thank you, Pamela, and thanks for that update in terms of where the book has come from the last conference. Do we have any questions in the room, first of all? Yes.
Yes, thank you very much for a really interesting presentation. I was wondering, when it came to rights that different people, so the accused and the victim, these probably have some, at every stage, different categories of people have. How do you balance rights between people in your normative framework? Is there a method in which you rank them and say why yours or both of yours in a given situation?
Yes, I mean, I haven't really
Sorry,
got...
Pamela,
Sorry,
for the,
I've got to repeat the question.
Thank you very much for that question. That's one that I was thinking of myself. So the question was asking about the different persons that you identified as being involved and how you balance those perhaps competing rights, as you suggested, that, you know, the victims might have competing rights with the accused. So how do you balance that in terms of your normative framework?
Yeah, I mean, I think that's a great question, and it is one I have been wrestling with. I think what it will come down to, I haven't got to that stage yet, but I think what it will come down to in any given situation is looking at the values behind the rights and then saying, well, does privacy trump something or other or not, you know, in this circumstance? So, yes, ideally you could say the accused has a right to cross-examine witnesses, but complainers have a right to not to be treated in a way that doesn't respect their dignity, etc. Which do you think is more important here? And then, of course, it'd be a question of looking at other safeguards and saying, well, what is it about personal cross-examination that is so important anyway? And that comes back to maybe the value of participation, effective participation, and the autonomy of the accused. And of course, in adversarial systems like our own, we very much value the idea of the two parties fighting it out, and the accused being almost in charge of that process. The accused can instruct their lawyer, I want this evidence led, I don't want you to lead that witness, this is the defence I want to put forward. But there comes a point when you say, well, that they can safeguard their effective participation and their autonomy rights in the process, even if you say, well, there's one witness out of the panoply of witnesses that you're not going to be allowed to personally cross-examine, but of course you can write your questions down in your lawyer and you can discuss which questions you want your lawyer to put. So that way, I think you're getting a fair trial, you're getting effective participation, but in my view, the value of the upholding of the complainant's dignity would trump that right. So that's all the kind of unpacking that would need to be done for each individual scenario.
Earlier presentation from today, but you've mentioned dignity a few times, so I was just wondering, in your view, if you thought that insofar as protecting dignity as part of this process is concerned, if there is or should be any role for the law of Delict interacting with this area.
Okay, thank you. So the question refers to the reference to dignity and whether there is a role for Delict in this area when thinking about dignity.
Goodness. I must be honest, this morning I was listening to your really interesting presentation and thinking, it's such a long time since I did anything, not since I was an undergraduate. So I think that, as you know, and as you mentioned, there's been these cases of women taking their rapists to court in the civil court and getting justice that way. That's not something I would touch on, I don't think, in the book at all, because it's already going to be possibly 2 volumes, she says to Barry. Now that I've heard that you can have 2 volumes, it's actually getting quite big, so I couldn't really touch upon that. But I think there are interesting dimensions of Delict. It would be good to have a conversation about where the line between criminal law and Delict lies and where it should lie, sort of thing.
Yes. When you're looking at the police, I wondered about, from a victim's point of view, a right to be believed.
So the question is, when you're looking at the police, is there a right from the victim's point of view to be believed?
Yes, I think that's really quite difficult to say that there is. I think there's been a lot of movement towards that, because certainly in some categories of crime, like sexual offences, I think victims very much got the impression that they were not believed, and police were highly sceptical, and that was problematic. I would much rather they took a kind of a neutral position. I mean, I remember reading there was a chief constable in one of the English forces who made an announcement about some inquiry into childhood sexual abuse, and he was wearing a badge which was for the Royal Society for Protection of Children or something, and he thought that was perfectly appropriate. And I was thinking, the police need to be seen as neutral arbiters in this, I think. I mean, even the use of the word victim, I've referred here to victims and witnesses in some of the chapters, because a lot of the literature on victims, it talks about victims, and of course there's the Victims' Charter and all of that sort of stuff. But generally speaking, if I'm talking in other chapters, I tend to use the word complainer. So I don't think, it's an interesting one, but I think a right to be believed is putting it too strongly. They certainly have a right not to be treated as if the police don't believe them, but I don't think that's quite the same as saying the police have to believe you. The police's job is to gather evidence, I believe, for both sides of the case. They should be looking for exculpatory as well as evidence of guilt. And that ties back in a way to what I said about this presumption of innocence as a kind of practical attitude. They should treat the accused as presumptively innocent. Yes, they're of course looking for evidence, but the evidence should be to find out what happened and then pass it on to the fiscal, not really saying we're starting out assuming this person's guilty.
Do we have one last question?
Hi. I noticed that on the list of trial rights, there was the right to vote for trial by jury. And I have 2 linked questions about that. One is, why do you see that as fundamental in the Scottish context, where it would of course be a novel idea? And secondly, would you see that as having any element of proportionality, or would you see it as applying essentially to anyone who's being tried for any offence?
Yeah. So the question asks about the right to request a jury trial. and whether, sorry, what were the 2 points?
The first question would be why would you see that as a fundamental right?
So why would that be a fundamental right for the Scottish context? And then come back to the second point.
Well, I don't think it is it should be a fundamental right in the Scottish context. I don't think it should be. I mean, my proposed normative framework is here are some possible potential rights. Some, you know, I've already sort of personally ruled out, like the right to personally cross-examine. The right to have a jury is in there, again, to engender debate about why is it that in some places, like in England, you have got the right sometimes to opt for jury trial, and it's very much seen as an important right that people have in England and Wales. Whereas it's not really a right at all in Scotland. It's entirely up to prosecution whether you have a jury or not. And it's, you know, so I don't think I'll be pushing for that to be recognised, but it's in there as a possible right because I'm trying to find a sort of framework that any legal system could use to say how do we map up, and then explain, well, we map up quite well or very well or totally, or if we don't map up entirely, here are the reasons why not. So again, it's in there, as with other rights that I mentioned, to engender debate about what is it that people see as being important about a jury. And if we do think it's important, should there be categories of crimes where you do have a right to a jury? I mean, you could say, I suppose, you have a right to a jury in Scotland if your crime is sufficiently serious. You know, if you commit murder, sexual offences, serious drug offences, you will get your jury, you know, but beyond that, whether you should have a right at lower level crimes, I think is more difficult. And that, in a way, it's almost a springboard to allow me to discuss things like, well, when is it that the prosecution decides to allow a jury trial? And, you know, in a way, in Scotland, you wouldn't really want a jury because when you face a jury, that means it's because you're probably going away to prison for a long time. You know, I was in the fiscal service many, many years ago, briefly, and my first jury trial was the guy who was charged with driving while disqualified and without insurance. And I'm sure every single member of the jury was thinking, why am I here? You know, in the grand scheme, that's really not that serious. But it's because he had done it 32 times already. And we were thinking, he's got to go to prison for a long time this time. So having a right to jury trial. What, to hint about the previous convictions? Or we should have a conversation about how you do that. Yeah. Well, actually, that was not a unanimous one. I was disappointed. There was one person who voted for not guilty, and I was outraged because to me it was so black and white, you know, it was so obvious. But as soon as I handed the sheriff the list of previous convictions, you know, I could see the juror going, oops, you know, that was me holding out there for an acquittal.
And sorry, you had a second part? Do you still wish to ask that? That's fine.
The second part is about proportionality, but
Okay, that's covered. Thank you very much, and thank you, Pamela, for your presentation today. And we'll move on to our second of the session and our final presentation of the conference today. And this is a paper that is by James Chalmers and Fiona Leverick, and it's entitled Reconstructing the Scottish Law of Causation in Criminal Cases. Professor James Chalmers is Regis Professor of Law at the University of Glasgow, and his main research interest is criminal law, evidence and procedure, but has broader interests in Scots law and Scottish legal system and the relationship between law and public health. And Professor Fiona Leverick is Professor of Criminal Law and Criminal Justice at the University of Glasgow, and her main research interests are in criminal law, criminal justice, criminal evidence and procedure, and particularly jury decision making, criminal justice systems responses to sexual offences, and prevention of and responses to wrongful conviction. Together, they've written the 4th edition of Volume 2 of the SULI textbook on criminal law, and are currently preparing the 4th edition of Volume 1. And the paper will be delivered this afternoon by Professor James Chalmers.
Thank you very much, and thank you, Pamela, for your paper. I enjoyed the anecdote at the end because not that long, I say not that long ago, it's actually pre-pandemic, which is now a very long time ago. I was cited for potential jury service, for which I'm eligible, and sat in the courtroom one day. I don't understand why this theft is being prosecuted before a jury. It really just is. There'll be an enormous schedule of previous convictions, and maybe I shouldn't be on this jury. But in the end, wasn't balloted, so didn't have to wrestle with my conscience at that point. In fact, don't know the outcome. As a bit of background to this paper, as Michelle said, Fiona and I are working on the 4th edition of Gordon's Criminal Law. We have somewhat belatedly produced and somewhat out of sequence the 4th edition of Volume 2. when we were asked to do this, to speak at this conference, looked at the plan, such as was for that, I said, well, at that point, right, well, we'll definitely have chapter 4 on causation, which I am the lead author on, ready in time, so we can present that. We don't quite have chapter 4 ready because the, sorry, let's see if I can actually, things haven't quite gone quite to plan. So my response to any difficult questions will be that that's a wonderful question, and I intend to fully address it when I get to that part of the chapter. But nevertheless, there has been enough work done on that chapter for me to, I hope, say something at least of some interest during this presentation. The updating work involved here is essentially about 20 years of case law developments since the previous edition. That's true for most of Volume 1, though there are areas where we're building on the work we did for a separate SULI volume in criminal defences, which doesn't give us quite a long time period to cover. Although, here we go. Going to have to press very hard for this to work. The amount of development in the case law on causation, as I'll go on to say, has not been enormous during that time. There's a body of case law. I would refer to perhaps most of that case law over the course of this presentation. But I wanted to start by trying to draw out some themes about this area of law. The first is that you have something of a divide quite often between the theoretical or academic study of causation, on which enormous volumes, both philosophical and legal, have been produced, and attempts by the courts to steer matters in a more practical direction. So you see a fairly well-known quote there from the civil case of Blackie, that really causation is actually it's a practical problem and is not an intellectual one. There is a very similar quote in the context of English law from Sir Frederick Pollock, that the lawyer cannot bother themselves with the metaphysical ideas around the idea of cause, which one academic, Michael Moore, in writing an enormous volume of law of causation, said essentially when people use that phrase, they do it to cover their own idiocy, because they don't really know what's going on. This is actually much more complex than that. But of course, related to one of the other points on that slide, this is still a matter on which a jury has to be given comprehensible and workable directions. If your theory of causation requires a 500-page monograph, it may not be suitable for charging a jury in the High Court. So there is a need to try and boil down these points in the practical sense in which the courts have developed. Now, in many areas of criminal law, increasingly, the law crystallises in the form of what is in the jury manual. There is a sample direction on the law of causation there. One practical consequence of devices such as the jury manual, it ties in fact with what Graham Brown was speaking about in a different context in the law of sentencing, is that as you develop formal guidance in this sense, you close off the prospects of successful appeals because you establish consistent practice. And it means that the process of the law developing by things going wrong and having to be fixed is somewhat impeded. But if that's because you're getting things right the first time, that's clearly a good thing. That said, of course, the jury manual cannot answer every question that could arise in this area. And judges do not and should not slavishly follow the formulation which is offered there. Although, of course, it is relatively rare for jury directions on the law of causation unless the point is central to make it into the law reports. You do, and it's quite difficult, in fact, in teaching this area of law to give students much by way of example of how juries are asked to deal with the law of causation. We do use, in the course we teach at Glasgow, a particular case called MacDonald, where Lord Hodge does give quite interesting directions on how causation might be understood, explaining to the jury about how you might lose your kingdom because of a horse not being properly shod, but that's not the issue they're having to deal with. And Gerald Gordon reported those directions in the SCCR as part of a much longer report, simply because there isn't much out there in terms of the published material. Nevertheless, the courts, as I've said, are keen to emphasise that this is fact-specific, that doesn't produce any problems, it said, in an important case called Ross, which I'll come on to later. One theme that I haven't marked out in this slide, but which is interesting, is the way in which you do see in certainly previous editions of Gordon, and something true in textbooks in many jurisdictions, greater use of reference to civil cases in this context. Ross is sort of, but also not really a civil case. Blackie, of course, is. Increasingly, you do see a divergence there, not because of any conscious decision to uncouple the law of causation in civil and criminal cases, but because the practical function of causation in criminal cases tends to be quite distinct. Essentially, you want your requirement of causation, amongst other things, to avoid injustice, to avoid people being held wrongly responsible for things for which they should not be held responsible. But in a great many cases, the requirement of mens rea in criminal cases will do that for you. Somebody will not be at risk of conviction for a criminal offence, because even if you could link this death in some way to their previous action, there is no question of the mental element existing. There are two particular categories of case in which that doesn't work. One, about which I will say more towards the end of the presentation, is subsequent contribution by the victim themselves after the acts on the part of the accused which are alleged to amount to a crime. The other, about which I'll say less later on, so I'll say a bit more now, is that of strict liability. Now that can arise in a regulatory context, and so less so in Scotland. Elsewhere, you do have a body of case law on offences such as causing pollution to enter a waterway, which may be regulatory. Then how do you deal with a situation where that results from something that isn't the fault of the usually company in that situation? For example, vandalism. How does causation avoid injustice in that situation? It also, however, can be of some importance in much more serious common law criminal offences, and particularly in relation to homicide, because, of course, as I suspect is well known, any assault causing death is necessarily going to be at least culpable homicide. That means you do have to grapple with causation in the law of homicide in a way that may not be crucial elsewhere. But that principle that where a death is caused by a criminality, or at least by something in the nature of an assault, that we attach the label homicide to it, that we regard it as that serious, is particularly important. It's something systems do not lightly depart from. Where common law jurisdictions have not applied that rule, as has historically been shown in some Australian jurisdictions, you have found political pressure to create things like one-punch homicides laws to fill a supposed gap in the law. So therefore, making sure you get causation right and don't attribute outcomes to people for which they should not be held responsible is important. Also has been important as the law of road traffic homicides has expanded beyond causing death by dangerous driving to situations where there was a degree of injustice being caused in cases where little or no fault was present in somebody's driving, but they were uninsured or they were unlicensed. But somebody, as in one English case, who was themselves really extremely intoxicated, drove their car into that person. Was that person guilty of an offence of causing death? In the end, that problem has been dealt with not with the law of causation, but by the interpretation of the specific offence involved. But it does, again, illustrate the problem, the kind of problem that can arise in the context of this law. So the structure of the law of causation the basic structure has been clear for some time. Recent cases do help to confirm, though, that in criminal law we are looking at two questions. First of all, we are looking for an element of but-for causation, that the result would not have occurred but for the actions, or perhaps exceptionally an omission of the accused. And directness, where the terminology does differ from case to case and writer to writer, so causation in law, proximate causation. The accused's acts must be a direct cause of the result. Without this, of course, the causation is the cement of the universe. Everything is connected to everything, so you need directness in order to avoid the causal chain becoming impossibly long. But for causation will generally be regarded as a question of fact. The cases, of course, may be extremely factually complex and rest on very complex forensic or scientific evidence. Legal difficulties do arise in two categories of case. One which has, in fact, come before the courts, these cases tend to come before the courts very rarely, is the issue of concurrent causation, where you have multiple causes at the same time. So supposing, for example, that you had to, let's say, kill a llama because it might have tuberculosis, but nobody wanted to take responsibility for that, and so you dealt with that by way of a firing squad. I'm just suggesting, because it appears to be quite difficult, has everybody in that squad killed the llama in that situation, if you have multiple fatal injuries being inflicted at the same time? Now, typically in criminal law, you can deal with that by way of art and part liability, or liability in concert. But in one particular case, Johnson, the question did arise of a situation where it might be said that there was not concert, and therefore you could not say that the parties were responsible for each other's actions, but that they could potentially have separately inflicted fatal injuries on the deceased in the course of an assault. And there, as Gordon had suggested in previous editions, and the case appears to confirm his view, you've really got two choices here. Either you acquit both of them, and obviously that's wrong, so the answer is you convict both people. And Johnson says that you do have to establish contribution. The appeal court really has to be a significant material contribution, but you have to establish contribution by both, but you can convict both in that situation. It cannot be, in practical terms, a defence to say, well, yes, I inflicted a fatal injury, but so did they, and so you can't prove which one of these injuries caused the death. Another more theoretical problem, and actually, apologies for mistaking the slide, should be Isabella Martin. Morby is an English case raising exactly the same point, is causation by omission, which poses largely a factual difficulty because it can be more difficult to prove that the absence of doing something had a particular result. There have been occasional suggestions of broadening the causal test, but they've not, despite a suggestion with the Law Commission in England, found favour, and I'll say no more about those. Okay. So direct causation is where the law plays a larger role. And the question here is largely one of whether occurrences subsequent to the actions of the accused break the causal chain. You will see discussions in this context about pre-existing conditions, but they are discussed simply to disregard them. The maxim is, of course, you take your victim as you find them. The fact that the victim has an eggshell skull, I'm still not entirely sure whether eggshell skulls are a thing, but we talk about it in this context nevertheless. The fact that the victim has a pre-existing condition that renders them susceptible does not break the causal chain. And just putting it that way illustrates why it is not, in fact, a question. It can't break the causal chain. It's something that happened before. The question may, of course, why you may escape liability, may be a question of mens rea. But again, remember, this is happening in the law of homicide. So there is no mens rea question beyond whether you have the mens rea of assault in the context of an assault causing death. A range of issues might be considered in this context. Again, fairly obvious ones. The switching off of a life support machine, assuming that that is not an interloper doing it inappropriately, is not something which is going to break the causal chain. The rare issue of assisted suicide is mentioned sometimes as at least a theoretical possibility. There is elderly and inconclusive Scottish authority. It can arise. There is a very tragic, quite horrendous English case, W. Williams, I think, from just 2 or 3 years ago now, where this did arise because a victim on whom very horrendous and painful injuries were inflicted chose, and one of the questions was whether this could really be regarded as a choice at a later date to travel to Belgium, I think they were a Belgian national, and to end their life through euthanasia. Did that break the causal chain? Now, ordinarily, English or Scots law, not quite so clear as we'll see, would say free and voluntary acts break the causal chain. English law recognises free will. But the court said this was a question that should appropriately go to the jury, because in these really quite horrific circumstances, it was perhaps not appropriate to say that this was a truly free and voluntary decision, and the question should therefore have been left to the jury. That the case was terminated here by a ruling by the judge, but sent back for retrial after that decision. Yeah. The Scottish courts, and this is the issue in which we could go into in more detail, if I could send the slides in the right direction. I promise I know how to use these things. I'm just out of practice after 2 years of a pandemic. The problem that has bedeviled the Scottish courts for some time, and it has now is in a slightly different context from where it started, is the issue of self-administration of harmful substances. And this goes back to a line of cases which I suspect many people will be quite familiar, but the leading case of Calic, which dealt with the problem of solvent abuse. And it's commonly cited, of course, in the context of the Scottish court's ability to flexibly develop the law, where the court said, well, if you supply children with glue-sniffing kits, the child's decision to abuse the solvent does not break the causal chain, and therefore you're responsible as the seller for the results of doing that. That was, and also that was charged as effectively a case of causing real injury, using older terminology. Very quickly decided by the courts that actually the fact that it was children implicated in that case, and the fact that it was a glue-sniffing kit prepared in a particular way, none of these things mattered. UOHAC a few years later, adults being supplied with a largely lighter fluid in that case, exactly the same principle, exactly the same offence. Where this possibly took a bit of, as the courts later discovered, a practical wrong turn was following a case called Lord Advocate's Reference, where, well, lots of cases are called Lord Advocate's Reference. A few nowadays, in fact, there are now very few Lord Advocate's References in criminal cases. But in 1994, where the trial judge upheld the submission of no case to answer on the basis that where a victim in that case had been supplied with drugs, methamphetamine, had taken the drug and died, that her decision to take that, Lord Coulsfield, I think, ruled, had broken the causal chain. There could therefore be no liability for culpable homicide. The High Court on the reference said that that was incorrect, that the causal chain had not been broken. After this, there was, in retrospect, it can be said, perhaps something of a wrong turn, because there seems to be an assumption for some time, well, if the causal chain isn't broken, then obviously cases of supply of drugs followed by death are culpable homicide, and many guilty pleas were entered on that basis. Now, that actually, we could speak in detail about this, that of course ignores the mens rea question, as the courts were later to point out in a case called McAngus and Kane, because this is not like an assault. This is not within the scope of unlawful act culpable homicide. Unlawful act culpable homicide doesn't mean all unlawful acts. It doesn't include offences under the Misuse of Drugs Act, so you have to prove the mens rea for, confusingly, lawful act culpable homicide. Okay, it's unlawful what you've done in supplying the drugs. You can imagine this is fantastic teaching to first-year students. This is clearly an unlawful act, but it's not that sort of unlawful act, therefore it's lawful act culpable homicide, and you have to establish recklessness, which may be very easy to do in some circumstances, may be quite factually difficult to do in others. But leaving that aside, going back to the causal question, the question was raised again in the Scottish courts following an English case, because the same factual pattern is, of course, quite common north and south of the border. And the English courts emphasise in a case called Kennedy, English law recognises free will. So if you supply drugs to a person and that person decides to take the drugs, different if you, for example, administer them, if you inject a person, that's not the same thing at all. If a person makes a deliberate decision to take drugs, that breaks the causal chain. Scotland, however, much more Calvinist, free will, not a thing at all. And so when the point came back for the court in two appeals heard together, McAngus and Kane, the appeal court of Scotland was we're not prepared to say that that breaks the chain of causation. In fact, what we said, slightly inconclusive, it will not necessarily break the chain. Okay? So the trouble with that, is described as practical but nonetheless principle by the court, is what is the test? How do you know when the causal chain has been broken? And we've a step towards that, and this is the final slide. In the civil case of Ross against Lord Advocate, well, it's a civil case, it's criminal in substance, because the issue that arose there was that Gordon Ross, now deceased, but a man who was terminally ill, challenged the decision of the Lord Advocate not to promulgate a prosecution policy specifically on assisted suicide, as had been done in England and Wales following Purdy, where it was ruled in the last House of Lords case to deal with criminal law, that such a policy was required by the strictures of convention rights. And that in turn gave rise by a chain, which I'll skip over slightly given pressure of time, about a question about the causal chain. So if a person who supplied drugs to a person or made them available, knowing that person might take them deliberately to end their life, is there causation there? Is that supplier a cause of death in that situation? Because if they are, and there is potential liability for culpable homicide or indeed murder, then the Purdy question arises quite acutely, and there really ought to be prosecution-specific guidelines. The court, in that case, took slightly different views, and I'll just finish with this. You can see from the quotes on the slide, Lord Drummond-Young did not actually say, I think, anything directly about this. Lord Carloway suggested, well, actually, the adult with full capacity, freely and voluntarily taking the drug with the intention of ending their life, that does break the causal link. Lady Dorian is more circumspect in that. That's relevant, but it's not conclusive. Doesn't tell us what the test is. What is practically important about Ross, and why Lord Carloway's views in this specific context are going to be particularly important, is it provides a clear basis for prosecutors to say, right, we are not going to bring a prosecution in this case, because the then not just Clark, the Justice General has told us that's not causation. It doesn't conclusively answer the point of what the general test is, or how this should be resolved in future cases, because of the difference in views of the judges in that situation. And that emphasises what Jill Gordon has talked about before, about the unofficial categories, the particular role of Crown Office in shaping the law as much as the courts. But at that point, I think I'm well over it, so apologies, and I'll stop.
Thank you very much, and thank you for highlighting all those challenges that you will face as you finish your chapter. Do you have any quick questions? Yes, John.
James, you may remember that when we worked together a few years ago, I actually wrote the causation bit, so I wrote both the civil and criminal liability. But one of the things that has happened in civil causation, so I'm thinking immediate principle of rights of contract and intellectual property and various other things as well, is that the model is very different from what it looks like even 10 years ago, certainly 20 years ago. And trying to work out why, do you think that really the key is the goal or goals of the area of law? You mentioned justice. That's one point. And so that if you're going to provide a theoretical understanding, you need to take that into, well, you really need to start with that.
So just to summarise that question, so looking at the developments, particularly in civil law in relation to causation, do you think that the underpinning purpose of the law plays a role in understanding causation?
Absolutely. I mean, this comes down to, in many of these cases, simply the question, is this something which a person ought to be punished? And also, not simply punished, but recognised as responsible for. One of the problems in some of the cases I referred to earlier, where you do not hold a person formally liable for the death, but hold them liable instead for an assault, as some jurisdictions would do, or a road traffic offence, is the perceived injustice and the perceived absurdity sometimes of not producing an outcome in terms of conviction which reflects the fact that death occurred. And that is simply not the same question which is normally arising in the context of delictual liability.
We perhaps have one final, very quick question. Yes.
Yes, so thank you very much for the very interesting paper. The analysis all starts from the idea that the act is known and clear. So I wondered whether in the chapter you'd be dealing with how to establish whether that was the case or not. I'm thinking particularly in the case of non-natural persons. So company law scholars of the corporate crime tend to say it's a criminal matter and I'm going to walk away. My understanding of criminal seems to be they say that's a corporate matter. Leaving a bit of a gap. And so the could causation or discausation pick up where that analysis ends?
So sorry, just when we're dealing with non-natural persons, is this a bit more problematic when defining the act in question? We're looking at causation.
Yeah, I think from a criminal perspective, I tend to regard the two as a separate question. I agree it's a complex question, but and we will deal, not in this chapter, but in, I can't remember the exact number, a very closely placed chapter with the question of attribution to corporate bodies for criminal acts. That does still tend in criminal law, outside of the context of the new legislation on corporate homicide, to still operate on the basis of, can we find a natural person to attribute this thing to? And is that person a directing mind and will of the corporation? Now, of course, in more regulatory events, you can have more scope for this hinging on an omission, where there will always be a directing mind and will who omitted to do it, because everybody omitted to do it. But in the case of acts, criminal law is still largely wedded to this idea of, can we find the natural person, and then can we prosecute the company off the back of that, which simplifies that analysis somewhat.
Thank you very much, and thank you to both of our speakers in this final panel, and indeed all of our speakers today, and all of our audience, both live in person and virtual via the live stream. So thank you very much for attending our 2021 SULI Showcase Conference in Scots Law, and we look forward to welcoming you in due course to our next SULI conference in another 2 years' time. So thank you, everyone.